Please don't mention hearing matters this week. Come back next week. The other matters, application order 41 to be mentioned, please hand over. Need not mention, hand over the slips.
May I be permitted to mention one matter, my lord?
What?
My lord, matrimonial appeal has been filed before your lordship.
Yes.
At the time of admission, my lord, some error detects, my lord. Error has been corrected, my lord, but one of the error was that the original judgment and degree, the date of the original judgment and degree are different.
The error is in the order.
My lord, error in the
Order, I sitting with whom?
lordship is not there. My lord, Posad, Madhuresh Posad, along with
If
justice.
there's a correction required, then you have to get that bench.
No, my lord.
You
not
cannot
correct.
mention before
My
us.
lord, order has not become, my lord. My lord, the original degree and order of
What
the
do you want now?
my lord, matter must be fixed in to be mentioned as because my lord, your lordship kindly direct to the trial court to correct the degree and order. Date of the degree and order are different.
Well, hand over the slip, it will appear as to be mentioned. Mention.
My
Yes.
May I have lordship kindly? Lordship, this is an order passed by my lord's sitting with Vivek Kumar. The small inadvertent error where my lordship directed.
Justice Kumar will come back next Monday. Mention it. Wait.
May I have your lordship's leave? Though this is appearing under the heading hearing, but this is ought to appear under the heading application.
What is the item number?
This item number 86 to 95. This is that Safema matter, your lordship,
All right.
where that
86.
technical point was discussed.
Oh, that.
Yes. That there's a stay application.
A slip of paper, please give the item number.
I have written.
We'll ensure that those will appear under the heading application.
Deeply obliged.
It is application.
And there is one more thing, your lordship. On the last occasion, your lordship directed us as because there's a technicality whether first appeal or second appeal. The first adjudicating authority's order was also supposed to be brought, which we challenged before the appellate tribunal. We have applied for a certified
copies.
We have applied. They have not handed over till.
We'll
So they have
care.
received all the copies, everything we have served as per your lordship's order, but they have not given it till.
We'll look into that when you take up.
WC appeal matter, your lordship, the respondent is proceeding with the execution. For the
It's an application.
It's an application.
Yes, applications we directed all slips to be handed over. Application order for to except hearing, final hearing, please hand over the slips. Don't mention.
In a matrimonial case, my lord, apart from granting divorce, my lord, the husband is sentenced to prison for 3 years.
So this is a hearing matter.
It is, my lord, lordship, kindly, my lord, this
We will hand over the slips.
because I accept divorce.
Understood. Understood. Shanghai George.
Lordship, one matter has been mentioned by learned friend upon notice. This is a case where they have not filed written statement for 4 years, and matter.
If you have allowed the mentioning, let it come up in the list. When it comes up, please point out. Please point out.
Item number 1.
Why is it appearing as to be mentioned?
my lord, kindly order dated 23rd December. Department is directed to file a report whether the LCR has come or not. Another portion order, they have paid the amount.
23rd.
23rd December 2024. Last order.
Lordship will kindly see the July 22 order. In that order, the direction was passed to bring the lower court records.
Right.
And it appears that my learned friend's client has already deposited the special messenger course. The lower court records have still not arrived, even though
My lord
assume
has
that
been
the parties are ready for hearing, the appeals could not be heard.
Have you checked up the whether the records have come? How recently have you checked up?
kindly see last order.
That was
my lord has been pleased to direct the department.
You can't get that order.
Kindly see the
No, 23rd December. Yes, you have got it.
last point number 4.
A report was to be given. Today is January 6th. A report দিয়েছে ডিপার্টমেন্ট কিছু দেখ একটা রিপোর্ট তো দিয়েছে দেখছি দেখি ঠিক আছে দিয়েছে এখানে আসছে দেখে নিচে This is which district?
Nodia Amla.
South 24 Parganas, Alipur.
We find from the records that despite repeated directions, the trial court records have not yet arrived. Full stop. The learned district judge, South 24 Parganas shall furnish a report as to the reason for such delay in sending the trial court records as well as ensure that the trial court records are sent immediately to this court as per previous direction. Stop. Such report shall be furnished by the learned district judge, South 24 Parganas, to the learned registrar general of this court, and shall be placed before the court on the next date of hearing, that is on January next date of hearing, next returnable date, that is January 26, January 27, 2025, when the matter shall next be listed under the same heading. Let this order be communicated to the learned district judge, South 24 Parganas, to the department immediately. এটা একটু ডিপার্টমেন্টকে বলে দেবেন যে যেন কমিউনিকেশনটা করে দেয় না হওয়ার সময় একটু জাস্ট ওদের বলে দেবেন ইয়েস
The mere order from lordships may not suffice. Learned friend also has to take the effective steps there. Lordship knows what I mean by
My
that.
lord's order.
what can be done so no this let this order be communicated to the district judge.
Now it may happen, but
Let us see what happens.
Direct the department to communicate this order through district.
For that also you have to take steps, further steps.
We have to take steps.
If the department, you have to take further steps for the department sending the order, then just inform us.
My lord. Grateful.
my learned senior friend knows what steps he has to take.
All of us know. Yes. Next. NP টা কি? Bracket এ NP আপনি জানেন না?
Non-prosecution.
Number two, the appellant does not want to proceed further with the case.
So you are protected with written instruction
Yes, with the.
for your own safety.
Yes,
You are filing that also.
I'll file a copy, my lord.
File a copy.
Fine.
Keep the original with you for your saving your own skin later.
Yes, ma'am.
Pero learned counsel for the appellants submits that the appellants do not want to proceed further with the appeal. Full stop. A photocopy of the written instruction in that regard filed today in court be kept on record. Accordingly, FA 138 of 2023 is dismissed for non-prosecution without any orders to costs. Stop. Interim order, if any, stands vacated. Thank you.
Much of it.
Item number 3.
Respond. There's a very small correction in
Yes.
the judgment.
Have you given a notice to the appellant? Because if they have any objection, it will be difficult.
It's a very small.
What is that correction?
Page 15, paragraph 53.
You're sitting with Justice Sen. Page 15, paragraph.
53. There is written Can 1 of 2023. It should have been Can 1 of 2024.
Oh,
Very small.
we find from the judgment dated December 16, 2024 that in paragraph number 53 thereof, comma, inadvertently, instead of within double inverted, Can 1 of 2024, double inverted close, comma, it was transcribed as our double inverted, Can 1 of 2023, double inverted close, full stop. Let the said number be deemed to stand corrected as Can 1 of 2024. পড়ে যাবেন আপনি নিজে পড়ে যাবেন
Item number 4.
Well,
Why unfortunate?
I have substitution application, but the condonation of delay section 5 application is misplaced from the bar. So, my lord, I
From
have
the bar or from the department?
the bar. My lord, this is
Acha, you have filed it.
have filed Can 2 is the Can 2 is the substitution application and
Your
Can-
copy has been misplaced.
Yeah, my copy.
Can 2 is the delay condonation of delay application.
Condonation of delay.
Have you served a copy on the other side?
I could not, my lord.
Oh, you don't have a copy.
My lord, I shall take photocopy of the from the court for speedy disposal, or my lord, I have applied for certificate copy, but
কোর্ট থেকে জেরক্স করার কোনো ইয়ে আছে এখানে প্রভিশন আছে আমাদের ডিপার্টমেন্টে পাঠিয়ে দিলে তাহলে কিভাবে অনেক copy of Can 2 of 2024, 2023, comma, that is the application for condonation of delay in filing the substitution application, only can 2 has been misplaced.
Only can to for substitution regarding
Only can 2 has been misplaced.
Can
Has,
on section 5.
comma, has been misplaced from his office and he does not have a copy of the same. Push up next para. Accordingly, the department is directed to furnish a photocopy of the said application and stroke or permit the learned advocate on record for the appellants to take out a photocopy from the court's records of Can 2 of 2023 for the purpose of enabling further proceeding in the matter. Push up next para. Let the file be sent down immediately to the department for such purpose. Push up next para. The learned advocate, the appellants stroke petitioners, comma, thereafter, comma, shall serve copies of Can 1 of 2021, comma,
And one will already substitution application.
allowed.
Substitution not yet been allowed.
Can
Actually,
1 of 2021, comma, Can 2 of 2023, and Can 3 of 2024.
3 allowed, my lord.
3 has been allowed.
Restoration application.
Acha. Can 1 of 2021 and Can 2 of 2023 to the Can to dismiss হয়েছিল? Dismiss for default.
Application.
Can 3 কি registration of that? ওটাই registration 14/5
ওটা restoration.
সেটা তারপর অ্যালাউ হয়নি দেখে নিচ্ছি তারপর আগে পিছনে আগে আছে কিছু Can 2 was dismissed for default.
Can
Your Can 3 is for restoration of that.
restoration allowed. But
When? When was restoration allowed?
restoration that last 14/12 or last order. Well,
দেখ আগে পিছনে আর পেছনে অর্ডার খুব বাজেভাবে সাজায় of 2021 and Can 2 of 2023 on the respondent indicating that the said applications shall be listed for hearing in the monthly list of February 2025. First up, the appellant shall file an affidavit of service to that effect. File will go down to the department immediately. Please take a copy from the department of Can 2, serve copies of 1 and 2 both, and returnable February when you will file an affidavit of service.
certified copy is necessary or well,
We have directed photocopy, but normal course certified copy should be given. But we have directed photocopy. If there is any issue, then apply. You do this thing. You apply formally for a certified copy. Let it go down to the department. And if the department pursues this order and can furnish a photocopy, it will be. If there is some technical difficulty, then you have that application and you will get that.
Great, thank
Item number 5.
Number 5, madam, the appellant. Madam, this matter I am praying for 2 weeks accommodation.
Why?
Because there are 40 respondent matters and out of
40?
40
Arising from a partition suit?
there is a partition suit. Out of 45 envelope has been come back matter, and out of 5 envelope, two people has been deceased matter. So my client could not obtain the legal heirs till now.
So why did you mention the application? It has come automatically.
I have not.
We'll direct it to go out of the list. We'll give you liberty to take steps. Learned counsel for the appellants submits that out of the several respondents, comma, some have met their demise in the meantime, comma, as it appears from the envelopes which have returned after service being sought to be effected on them. Accordingly, on the prayer of learned counsel for the appellants, comma, to enable learned counsel for the appellants to take appropriate steps for substitution of the deceased parties, comma, let the matter go out of the list with liberty to the appellants to mention the matter as and when appropriate applications for substitution are filed. Thank you.
Item number 6.
About the respondent, my lord.
Yes. What is the application? What is the connection in which this is coming up?
The police, one application is for granting a police for implementation the order of status.
Right.
For substitution, my lord.
These are appearing from the department or somebody mentioned it? Let us check up.
Department subject.
No, mention. Oyan Mitru.
Is there?
Mr. Rai or Mr. Mukherjee, please ensure that a notice is given to you. We will keep it day after tomorrow. None appears for the appellant stroke petitioners at the time of call, although the respondent numbers 2, 3, and 4 are represented through counsel. Push up next para. The learned advocate on record for the appearing respondents is requested to serve a notice on his counterpart appearing for the appellants, indicating that the application shall be listed next on January 8, 2025, when a receipt of such service shall be filed in court.
Right, number 7, my lord, I'm for the private opposite party, my lord. I pursuant to
Private
order
opposite.
passed by your lordship on the last occasion, my lord, I have seen, my lord, there is a direction to the appellant to serve a copy upon the respondent, my lord. Till date, my lord, we have not received, my lord, but my lord, I got the matter, my lord, since long, my lord. If your lordship kindly direct.
No copy. You have got a copy subsequent. You are for the private respondent.
My-
Learned counsel appearing for the private respondents submits. You are the land losers.
My lord, I'm for the, my lord, to be very candid, my lord, I forgot the entire matter.
Learned counsel appearing for the private respondent submits that no copy of the memorandum and/or applications has been served on the said respondents as per the direction of this court dated December 10, 2024. Push up next para. Accordingly, the appellant is directed to ensure that such service is effected at the earliest. Full stop. The matter will next be listed in the monthly list of February 2025 under the same heading.
Deeply obliged.
You can also contact Mr. Supratim
My
Dhar is
lord,
appearing.
my lord, I will take
Yes.
the copy.
Just
and my lord,
informing
I
that this order.
will- At my cost, my lord, I will take my copy, my lord.
No, he has to be at the cost.
Deeply obliged. my lord.
Otherwise, we'll impose cost upon you if you bear the cost. Yes.
Deeply obliged. my lord.
Number 8, 8, 9. Your Lordship, I am for the appellant, your Lordship.
Yes. Yes.
And I'm representing the respondent number 8, 9, 10 in their application, and subsequent in 9, I'm for the petitioners.
All right.
Can 5 is my application for substitution of the respondent number 8. He has expired on November 18th, your Lordship. This is my application.
That is can
5.
And can 3 in our application, that is in 9.
Acha. Acha, very well. Can 5 in FA 50 and can 3 in FAT 296.
My lord.
So you agree that he has died, that person has died.
My lord.
It has been filed within time.
Yes, sir.
My lord,
Yes.
delay was there in filing the main application, and for that reason, can 2, that is the stay application in
Then
my,
not with.
Their appeal.
in my appeal, that is item number 9.
Oh, acha, acha, acha.
The appeal was filed at a belated stage, your Lordship. So there is a section 5 with relation to their appeal.
Your application, let us allow, and then we'll look into his. What is the reason for your?
My lord, there was 92 days delay. Your lordship will kindly appreciate that other than me, there were 17 more respondents in my in their application.
Right.
So ultimately, what happened is it was a bit critical decision that appeal will be filed jointly or separately. This was the first.
So what is the reason you have given in your application?
My lord, I have. It is in starting from page number 10 in.
Good number. This is the exact reason you have given. We'll accept that. Ms. Dotto will accept that explanation and allow his application also. Let him be implemented. Let the AS be implemented.
Whether the section 5 is relation to their filing of the appeal, not substitution.
Oh. Then the substitution has to be allowed first. Your substitution application is in time. We'll look into the section 5 later then. Can 5 of 2022 in FA 50 of 2019 has been filed for substitution of the heirs and legal representatives of the deceased respondent number 8. Full stop, next para, we find that the application is in form and in time. Full stop, accordingly, Can 5 of 2024 is allowed in terms of the prayer made therein, comma, directing substitution of the heirs and legal representatives of the deceased respondent number 8 in the appeal. Full stop. There will be no address to costs. Full stop. Necessary consequential amendments to the memorandum of the appeal shall be carried out by the learned advocate on record for the appellant during the course of the day. Full stop. Next para. Can 3 of 2024 is an application for substitution of the heirs and legal representatives of the deceased. He was appellant number?
Appellant number 8. Appellant number 1 in my application and in their application.
This is appellant number 1 in FAT 296 of 2018. Full stop. This is also in time.
In time.
Full stop. Since the application is otherwise in form and in time, comma, we allow Can 3 of 2024 is allowed, comma, thereby substituting the heirs and legal representatives of the deceased appellant number 1, full stop. There will be no arrest to cost. Necessary consequential amendment to the memorandum of the appeal shall be carried out by the learned advocate on record for the appellants during the course of the day. You will carry out that correction in your appeal.
My lord.
Now, the section 5 application. Yes, what do you say to the section 5 application?
My lord, that is my application.
Yes, what do you say to them? You have said what you have to say. What do they say?
They were also.
There is a confusion as to whether composite appeal. We like accept this. What is the number of it? Can 2? No.
Can 2.
Can 2. Very good. Can 2 of next sir. Can 2 of 2019 within bracket old number can 10563 562 this should be.
562 is the continuation application here.
Yes.
10562. No, previously it was numbered as 10562. Thereafter.
No. Then thereafter 62 has become can 1, not can 2.
Yes.
As reflected in the list.
10562.
Huh.
62. That is the deal.
Can 2 is the condonation application.
Condonation application. That
আচ্ছা যেটা বললাম can 2 বললাম না ওটা can 1 of 2019 within bracket old number can 10562 of 2019 has been filed for condonation of delay of about 92 days in preferring the appeal. Full stop. Upon hearing learned counsel for the parties, comma, we are satisfied that sufficient cause has been shown for the said delay. Full stop. Accordingly, can 1 of 2019 in FAT 296 of 2018 is allowed, comma, thereby condoning the delay in preferring the appeal. Full stop. FAT 296 of 2018 shall be deemed to stand accordingly registered and admitted. Full stop. There will be no arrest to cost. Any other pending application? What is
There is a stay application,
in our
appeal. My appeal is ready for hearing. It's from the same judgment and decree, Your Lordship.
Why did you wait for so long to move the stay application?
My lord, actually, that time the advocate who was appearing.
What is the impugned degree? Same judgment has been challenged.
Same preliminary decree.
Same preliminary decree.
Preliminary degree, yes.
They are also enjoying the stay in this regard. And
no, what is the stage of the suit? The final degree has not been drawn up as yet. So we'll pass the usual direction. The final degree proceedings will continue. No final degree will be drawn up. That is can what?
Can 2 subsequently will go.
This could be can 2 then. Yes. 563. Very good. এরপরের হেডিংটা হবে can 2 of 2019, হ্যাঁ, bracket old number. The present application has been filed for stay of the impugned judgment and preliminary decree passed in a partition suit. Full stop. Next para. Upon hearing learned counsel for the parties, comma, the trial court is directed to proceed with the final degree proceedings in the partition suit. Full stop. However, comma, no final decree shall be drawn up without prior leave of this court. Full stop. There will be no orders to cost. Full stop. Next para. Learned counsel for the appellant in FA 50 of 2019 submits that the paper books have been prepared in respect of the said appeal and the appeal is otherwise ready for hearing. Trial court records have arrived also. So you have to add their memo. Have you added their memo also? No.
Because it was filed
Should-
subsequent.
And subsequently,
so-
no execution of the
So
preliminary
we'll direct
decree
you
also.
to we will direct you to file a supplementary affidavit, a supplementary paper book incorporating the remaining papers. Please just have a talk with her and what are the remaining papers? You will give you a fortnight's time for doing that. Only the memo probably and if you have any.
My lord.
Next para. Learned counsel for the appellants in FAT 296 of 2018 shall file learned counsel na kore, the learned advocate for them. FAT 296 of 2018 shall file a supplementary paper book incorporating the remaining papers, comma, including the memorandum of FAT 296 of 2018 and serve copies thereof on the learned advocate for the appellant in FA 50 of 2019 at the earliest. Full stop. Next para. Both the appeals shall be listed for hearing analogously in the monthly list of February 2025.
My lord, also praying that no execution of that order in my case.
What is the question of execution? Preliminary decree.
Preliminary decree.
Where there is no execution.
My lord.
The execution is the final degree proceedings. That will continue, but no final degree will be done.
My lord. Grateful, your lordship.
Your shares have been declared.
My lord.
So execution can only mean that your client has to be executed. Then otherwise,
And that was actually what was declared. It is totally neither it is up to my satisfaction nor it is up to their satisfaction.
then it will not be to our satisfaction also. We'll sit
My
aside
lord.
and send it back and
Grateful.
whatever happens.
Grateful.
Let it appear in the February list, we'll do what.
Grateful, your lordship.
Yes.
My lord, I am appearing for the
I am happy with the response.
What is scan 2? You are the appellant. You are the petitioner also.
substitution application. My lord, this matter, my lord, I submitted on the last occasion. I lost the brief, my lord. Thereafter, my lord, I took out a call. Yes.
Got it.
Substitution, no, I didn't get the brief, my lord. I will take it from the department, my lord. But the substitution, your lordship's desire was that let the substitution application be done, and LCR also did not arrive. So
Have you put in the requisites? You probably have not.
there was
No direction. Substitution, what is the delay?
My lord, delay, my lord, technical sense, my lord, it was during the COVID pandemic. My lord, I have explained, my lord.
Yes, Mr. Ahmed, what do you say?
That to that extent, I don't oppose my lord.
So we'll allow the substitution, we'll direct the pass the necessary directions, put in requisites and all those. Very well. Can 2 of 2022 is an application for substitution of the heirs and legal representatives of the deceased appellant number 1. Full stop. Next para. Upon a perusal of the
No, my lord, it's a composite application. My lord, your lordship, appellant number 1 and also plaintiff appellant number 4. I have
oh acha
put in the court fees, my lord.
appellant number 1 যেখানে বললাম and appellant number 4 যেখানে appellant number 1 বলেছি ওখানে appellant number 1 এর সঙ্গে and appellant number 4 কথাটা ঢুকে যাবে বলে সেন্টেন্সটা কমপ্লিট যেরকম হয়েছে next upon a perusal of the application comma we find that sufficient cause has been shown for the delay in preferring the application full stop accordingly can 2 of 2022 is allowed comma thereby condoning the delay in filing the application and setting aside abatement with regard to the demise of appellant numbers 1 and 4 in the appeal and directing substitution of the heirs and legal representatives of the said two appellants in the appeal. Full stop. There will be no orders to cost. Full stop. Necessary consequential amendments to the cause title of the memorandum of appeal shall be carried out by the learned advocate for the appellants, learned counsel for the surviving appellants during the course of the day. Full stop. Next para. The appellants shall put in special messenger costs for bringing the trial court records, and the trial court records shall be brought by such special messenger. Whose of such costs, along with other requisites, comma, if required, comma, shall be deposited within a week from date. Full stop. In view of appearance of which are you are appearing for which of the respondents?
All the respondents.
In view of the appearance of the respondents through learned advocates, comma, service of notice of appeal on the respondents is dispensed with, full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate on record for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment for the purpose of hearing and as and when the same is made ready for hearing.
But amendment has to be done by the advocate on record.
Advocate on record during the course of the day. Otherwise, it will take more time if the department is directed. But during the course of the day, please ensure.
Item number 11, Riya Banerjee is appearing on behalf of the respondent, my lord.
Yes.
She has been suffering from, I've been told, my lord, she's been suffering from high fever from Saturday.
Ask.
Had a week's accommodation, my lord.
What do you say?
For the petitioner, so if affidavit in reply has.
No, let them file the opposition first. Come back on the next day. On the prayer of the respondent, the matter is adjourned till when? Give us a date.
Anytime next week, 1 week's accommodation.
On the prayer of the respondent, the matter is adjourned till January 13, 2025. Full stop. Although learned counsel for the appellant seeks to file an affidavit in reply, comma, since the opposition has not yet come on record, comma, learned advocate for the appellant is requested to file it on the next returnable day. You have recorded that you are ready with that reply.
Great.
Item number 12.
Item number 12, Your Lordship, I am for the appellant petitioner, Your Lordship. This is an application. This is an application under 24 of the Hindu Marriage Act, Your Lordship. Petitioner does not want to proceed with the application. My instructions are that she wants to hear out the appeal.
Don't want to proceed with the very good. No difficulty. So you are the appellant.
I am for the appeal.
The records have not yet come.
Records have come initially, but due to some defect, it has been sent back to the trial court.
So we'll direct you to put in special messenger costs so that those come again.
Very good.
We'll do that. What is the can? This is 12.
And 1, Your Lordship.
Can 1. Learned counsel for the appellant, comma, on instruction, comma, submits that the appellant does not want to proceed with the application for maintenance in order to expedite the appeal. Push up. Accordingly, can 1 of 2019 within bracket, old number can 2625 of 2019 bracket closed is dismissed for non-prosecution without any orders to cost. Push up. Next para. Since the records, comma, it is submitted, comma, were sent down due to some defects for the purpose of correction of those, comma, the appellant is directed to put in special messenger costs within a week from date. Push up. The records, the trial court records shall be brought by such special messenger at the earliest. Push up. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Push up. Liberty to the parties to file to mention the matter, to mention the appeal as and when the same is made ready for hearing. Full stop. Next para. Service of notice of appeal on the respondent is dispensed with in view of appearance of the respondent through learned advocate. Yes.
Two appeals are filed, my lord. One by the state and one by the referring claimant.
You are the claimant.
I am the claimant. Second matter, I am the appellant.
Right.
My lord, in this appeal, my lord, both of parties, my lord, filed application, my lord, under Order 4120, Rule 27. On the last occasion, you
will direct those to appear along with the appeal.
Directed on 3rd December.
On the 3rd December.
Application shall be heard along with the appeal, and the appeals were fixed. Now they are coming under the head application instead of here.
3rd December, my lord, your
appeals are ready, paper books filed.
শুনুন না বলছি appealটা direction হচ্ছিল hearing এর জন্য learned counsel for the parties that the applications, comma, both under Order 4127 of the Code of Civil Procedure, comma, were directed to appear along with the appeals for hearing. Push up. Next para. However, comma, since the matter is appearing inadvertently under the heading application, comma, let the appeals along with the applications be listed under the appropriate heading for hearing of the appeals tomorrow. Let it be in the list tomorrow. We'll take up when the regular bench reacts.
Caption of hearing.
Hearing, yes.
Hearing.
We have made that clear. Appeal hearing এর জন্য দিয়ে দেব। Thank you.
Item number 15.
Yes.
Mr. Bhattacharya appearing for.
Mr.
Bhattacharya.
Which Bhattacharya? Acha, yes. So what?
Appellant, he has left the court for some personal difficulties. I only praying for not.
On the last occasion also adjournment was sought. We won't go on giving adjournments.
But on this matter, I don't.
Pursuant to last adjournment, Milord, they have already now filed, Milord, the application for condonation of delay in preferring the substitution application.
That is not appearing today.
See, Milord.
That is appearing today.
Yes.
So if they are asking for time,
Yes, Milord, kindly make it day after tomorrow.
an adjournment is sought on behalf of the appellant. Full stop. Let the matter stand adjourned till January 8, 2025. Day after tomorrow.
Number 15. Lordship, I'm appearing for the appellant, your lordship.
Yes. Is he appearing for the first time? No.
The last date was on the 23rd of
They were
December.
appearing on the last occasion.
Yes, your lordship. On the last day, as per the order of the last date, your lordship.
Yes.
5 of 2022 had to be placed in the monthly list, your lordship. In the last occasion, your lordship, I had made a submission that the CAN 5 application at this juncture cannot be heard without hearing out the appeal, your lordship.
What is CAN 5 for?
Your lordship, the CAN 5 application was filed by the respondent number 1 for the refund of the entire decretal amount, your lordship, that we had submitted as per the order of 13th October 2020.
No,
For the
this is.
stay of the for the stay of the
You had
decree-
deposited that amount as a condition of the stay.
Yes, your lordship.
The appeal is otherwise ready for hearing.
Yes, your lordship.
You have filed the paper books.
Yes, your lordship.
Are you sure on that?
Yes, your lordship.
So we'll record your submission on that and direct the appeal. We'll direct the application to appear along with the appeal. The appeal is otherwise ready for hearing, she says.
But Lordship, kindly come to the CAN number 5, Lordship.
Yes.
Number 12, Lordship, annexer P. No.
Page number 12. Right.
Page number 14, Lordship. The letter they have intimated to the respondent landlord for vacating the premises. It specifically.
What is the impugned decree? It's a money decree.
Lordship, it's a enhanced rent.
So money decree.
Money decree.
You got a decree for them to pay enhanced rent.
And that is deposited because the.
So they try to surrender.
They have surrendered during pendency of the appeal.
Very well.
And they have also said that the second para, Lordship.
Yes.
We shall have no further right there.
No, they don't have. They say that. Admit that. Yes.
And also they have undertaking not to proceed with the appeal also, Lordship. The agreement is also on the next page, Lordship.
Where is that?
The next page is the appeal, the agreement, Lordship.
Agreement signed by both of you. Achha.
And in this page,
Where do they say that they don't?
Otherwise, not shall have any right or.
Where? Which page?
The second page, second para, page 14.
No, that is independent. That is as a tenant, they won't have any further right. They're surrendering the tenancy.
Claim also. And
no, not about the money claim. They appealed it.
And agreement was declaration was executed by the parties, wherein they have stated that they have withdrawn all their application, our execution case also, and their appeal also.
Your execution, they cannot withdraw.
No. Our execution, I will withdraw, and their appeal there.
What was that portion of the agreement? Indian quit and vacate, which was subject matter. Who is the second party then here?
Second part is the
them.
Bata.
Or Bata.
Bata.
Bata means them.
The appellant.
Appellant. So the second party sent a letter to the. No, they only hand over peaceful possession. They don't say they won't, they would withdraw the appeal.
Yes, Your Lordship.
Never say that.
Page 18, para 2, para second. Lordship.
Read it out. They say ready and willing to quit and vacate and hand over
Lordship.
the property which was the subject matter of the suit, appeal, and the execution case, and requested the first party to take necessary steps to withdraw all pending proceedings regarding premises, such premises, after getting peaceful possession. So then you are to withdraw your execution. That's the agreement. So you are bound by this, withdraw the execution, will dispose of the appeal.
That has been withdrawn.
Execution case has been withdrawn.
Instruction.
So we'll direct the money to be released to them. Whatever money they have deposited in this court, we direct that to be released to them.
Instruction, whether it is withdrawn or not.
Lordship, also in the Can 5, Your Lordship, we have mentioned that there was 3 lakh rupees which we had deposited as security deposit.
Yes.
As per the handing over of the demise premises, we were entitled to get a refund for it. Your Lordship, we have handed over, we have given a letter also. Your Lordship, till date, the security deposit has also not been returned to us.
But then your application you cannot move. You cannot move your application then. Rather, it has to be dismissed on what you are submitting.
Then if you want to take instruction for that, whether they have continued with the execution or not, or the appeal be heard out.
The present application, Can 5 of 2024, has been filed by the decree holder for withdrawal of the amount, withdrawal of the decretal amount, which was deposited by the judgment debtor stroke appellant as a condition for grant of stay of the execution of the connected execution case. Full stop. Next para. Learned counsel for the respondent stroke applicant submits at this juncture that he is required to take instruction as to whether his client shall proceed with the execution case in view of the surrender of the subject property in the meantime by the appellant in favor of the respondent, and the agreement entered into between the parties, which is also annexed to the application. Full stop. Next para. In order to enable learned counsel for the respondent stroke applicant to take such instruction, let the matter stand over till January 13, 2025, when it will be listed under the same heading.
14.
Why? 13 you have any difficulty? Unlucky day?
No. It's not for unlucky.
1 week we are giving you sufficient.
Just
you will not be there.
One day.
Very well. That's January 14. It will appear on January 14.
Great.
We have recorded the reasons and take instruction. Yes.
Item number 17. Yes, my lord, I am appearing on behalf of the respondent.
Yes.
But I am appearing on behalf of the prisoner. This is the application for substitution.
Within time?
Yes. Substitution within time. Yes. Just let me check. He died 24th April 2024.
April 22. When was it filed? Let us see that.
It was filed on yes.
13 June, May, June. Yes. Right. So you'll allow this application. Who has died?
In original will, there were 2 executors. Will was filed, a succession case was filed by my learned friend. Succession was granted.
Succession case. This arises from a succession case.
Yes, succession case was
filed in before
succession
the
case was
Lord
filed.
Chief Judge, City Civil Court.
Yes, ma'am. Let her finish. Let him finish, and we'll come back.
Here, my client entered appearance and make submission before the learned judge that there is a will. This is pending, which is
probate is pending.
Yes. In spite of that, the date was fixed for hearing of that application. The matter was put up behind back of my client, and order was passed.
That is the challenge in this
That
present.
is the challenge in this appeal. But during this pendency of this appeal, the original 2 executors were there. 1 executor died, who has appeared before the City Civil Court. So this application for substitution of the name of the 2nd executor, who is alive.
Oh, the first executor who has died, he was conducting this.
Yes.
They were not jointly doing. Then it has to be. Yes. This is in the nature of Order 20 Rule 10 rather.
Then, my lord, I am filing Can 3, Can number.
Can 3 is appearing before us also.
Yes.
Can 3 is their substitution appeal.
Yes.
So we are allowing that. And do you have anything else?
We are filing opposition.
Lordship, we have certain objections
To this Can 3.
Can 3. That's why we are.
Were you directed to file any opposition?
Mistake is there. That's why we are taking 2 weeks time for filing this.
What is the mistake?
Mistake, my lord?
If there are technical mistakes, then we can do that right now. Because these are pending on technical grounds. All these appeals are pending for technical grounds for years.
Page number.
Oh, you're ready with the opposition? So why were you taking 2 weeks time?
But the
Yes?
information is not completed on account of a defect, my lordship.
Effect of the
At page number 2.
Paragraph.
Yes. What is the defect? What is your objection to this application basically?
Basically, lordship, Learned State City Civil Court was pleased to grant succession certificate in favor of the respondent, in spite of objection made by the original appellant. Lordship, this instant appeal was instituted by one Brojendranath Mondal, and accordingly a leave as an intervener was sought by the said Brojendranath Mondal during his lifetime, which is registered as CAN number 2.
What happened to that? No,
During the life-
Brojendranath
Mondal
was the first executor who had
as executor who during his lifetime preferred the instant appeal.
Ajay, the probate application has been allowed it.
My lord, what happened? They have
That's why
applied for
friend is
probate,
correct.
and on being objected being raised, the said probate proceedings converted into a OC case number which is
No,
registered as
do you object to that will itself?
uh,
Do you object to the will also?
will also.
So that's why you say that he is not the executor. There is no will set. Therefore,
I have annexed the copy of
no.
the
Then we have to give them an opportunity to file an opposition. This opposition to form in
I have already annexed the bill where the name of the petitioner is appearing.
No, you'll have to consider the objection and you file. But what is the technical defect? Why 2 weeks? Take it. Do it within a week. Do it within. Give a copy to them. Do it within 1 week. Give a copy to them so that they can use a reply. We'll keep it after 2 weeks.
I am undertaking to serve the copy upon the appellant within 2 days.
Fair. Fair enough. CAN 3 of 2024 is an application for substitution on the demise of the alleged on the demise of one of the alleged executors to the will of what is the name of the testator?
Siddhartha Ghosh, since deceased.
One Siddhartha Ghosh. Full stop. Next para. Learned counsel appearing for the respondent raises an objection and disputes the execution of the will itself. Full stop. On the pair of the respondent, comma, the respondent is directed to file affidavit in opposition to the application within a week from date and serve an advance copy of the same on the learned advocate for the appellant within such time. We are giving 1 week's time to give copies. Full stop. Next para. Reply, if any, shall be filed within a week thereafter. The application shall be listed for hearing under the same heading on January 27, 2025.
The advance copy maybe, sir.
Yes. Within a week, sir, you take another week. January 27. Yes.
Much.
Thank you. Yes. 18. Yes. You are for the appellant.
I'm for the appellate.
Appellant application. Applicant.
Yes, my lord. On the last occasion, my lord was pleased to direct.
That appeal from original degree you have done.
Shall be done.
Shall be done.
By this day.
What is CAN 1?
CAN 1 is a Section 5 application. There was a delay in filing this appeal of 141 days.
You have to serve a copy and come back then.
Yes, my lord.
There was no caveat.
No caveat.
We'll direct you to serve a copy and carry out this correction during the course of the day.
I have served upon the all the respondents.
Affidavit of service? There was a direction for service.
Principal respondent has not received yet. That is why.
Had we directed you to serve copy or of your own you have
Yes,
served?
on the last occasion, my lord had served.
Yes, shall serve a copy.
Yes, my lord.
For principal respondent, what happened?
He has not received yet.
So you have to
I will
affirm.
again serve upon him.
Very well, serve and file an affidavit of service. We'll give you another 2 weeks time to.
My lord.
Very well. Learned counsel for the petitioner submits that the principal respondent could not be served a copy of Can 1 of 2024 till date. First up, next para. Accordingly, the matter is adjourned till January 20, 2025, when it will be listed under the same heading, when the appellant stroke petitioner shall file a proper affidavit of service. Full stop, next para. The learned advocate on record for the appellants shall cure the defect as pointed out in the order dated December 18, 2024 in the memorandum of the appeal during the course of the day. Please do it. Well. Thank you.
Item number 19 of the dance for the petitioner led
Yes.
Mr. Shantan Basu, my lord. My lord, today we are submitting the reply, my lord, and I am only praying for a day's accommodation. Mr. Basu will
Earlier
argue
it
on the
was
matter.
solved, my lord. It was solved, nothing in this matter. If your lordship, my lord, only
There was
No, if there is nothing in the matter, then Mr. Bosu is required to be there all the more.
order was to pay 25,000 ad hoc royalty
that
by
was
our
not the
division
order,
bench.
Oh, you are the
Yeah, I'm for the respondent. I have paid the amount, it is admitted, and not only that,
This is regarding copyright or something? Royalty copyright?
royalty
Work
copy that they were supposed
Because
to
you're a publisher, that's why.
submit
And-
the quarterly statements, which till date they have
same,
not.
same application, similar prayers, we have filed
My-
application before.
Let Mr. Bose come. Where is your reply? Farouk? The affidavits in opposition and reply filed today be kept on record. Full stop. On the prayer of the appellant, the matter is adjourned for the day. Please come back tomorrow. We'll hear it. Tomorrow. What's the difficulty? You are ready today. You can be. Here. Thank you. Thanks. What's that? ওটা অ্যাপ্লিকেশন না ওটা তো বই বিক্রি করেছে এবারে অথর আর পাবলিশার ওটা রয়্যালটি ফয়েলটি দেয় ওই অ্যাপ্লিকটা হ্যাঁ কারণ পাবলিশার রয়েছে যখন দেখে অ্যাপ্লিকেশনটা ওই টাকাটা দেওয়ার জন্য None appears for the parties at the time of call. Let the matter stand adjourned for the day. আগের দিন অ্যাপিয়ার করেছিল
Right now, 21, I am appearing with the appellant, my lord.
Yes.
But I am praying for not today, my lord. Because we are engaged in.
One was allowed. One was allowed.
I am appearing for the respondent, my lord.
Right.
But just, today I have come to affidavit in opposition against the injunction application, my lord.
So then you give a copy to them.
Is affidavit of service, my lord.
My lord, kindly adjourn this matter for this week.
You can serve today.
No, my lord, just now I affirm today, my lord.
So you are filing your opposition today.
Yes.
So you get an additional ground for adjournment. More than one day. Affidavit in opposition filed by the respondent and the affidavit of service filed by the appellant today be kept on record. Full stop. Since a copy of the affidavit in opposition is served here and now on the learned advocate for the appellant, comma, the time for filing reply is extended for a week from date. Full stop. The matters shall next be listed on January 14, 2025. Please give a copy before that to him of the reply.
Sure.
Thank you. Thank you.
Item number 22, my lord, I am appearing for some of the respondents.
Some of the rest, which of, yes, we have got the numbers.
Appellant, my lord, led by Mr. Suprabhat Bhattacharya, my lord. Today, my lord, he has not come to the court. I am praying for not today, my lord.
What is the matter about?
Application.
My lord, already served.
Beyond time.
Tried on, my lord, August 2024, filed in December 20.
Copy was not, my lord, served upon us by the.
You are the appellant.
No, my lord, I am for-
Your application.
My lord.
So why don't you move the application? Substitution application, probably they will agree. Not formally, but you are the advocate on record. Why are you without brief?
Today, I came from my native house. That is why, my lord.
You had to come back last night then.
Not today, my tomorrow, my lord.
No, not as a matter of course. You are the advocate on record. You have to be ready on a substitution application. We are very strict on these things. We dismiss for default then.
Today, my lord, I came from my native house, my lord. That is why, my lord, I have.
If that happens every time, then you take your papers to your native house. You have come back, you have got time to enrobe yourself, get prepared for court. You didn't have time to take out that application and come with that. See, you should have come undressed then. If you got time to do that, if you got time to have your breakfast, why not have a copy of the application? It's a substitution application. Why shouldn't you dismiss for default? Give us one reason. You don't have a matter of right regarding adjournment. It's a court's discretion. And this is a fit case where Order 17 applies, we should reject it. An adjournment is sought on behalf of the petitioner, appellant stroke petitioner. First up, as a last chance to the petitioner to move the application, the same is adjourned for the day. If he is not there, please move the matter tomorrow. Substitution application, 3 months delay. You're taking time.
Item number 23.
I'm appearing for the
Yes, please. What is
the
that?
service has been effected. My lord, there is one mistake. My lord, it has not been affirmed as yet.
Great mistake.
Great mistake.
You can do it during the course of the day, then we can take up the matter. All have been served. What is?
Service has been completed.
What is the application? Move the application, we will grant you liberty to file.
Regarding, my lord, the stay of this, my lord, the operation of the judgment order, your lordship earlier, my lord, directed to, my lord, till the disposal of the application. Thereafter, my lord, not affecting the service of notice, your lordship, my lord, passed an order, my lord, restricting the order, that
Till
is 15 January.
What is the nature of the
Nature of the impugned order, my lord, the suit for, my lord, the partition, that regarding the demarcation and share of the property are disputed. Counterclaim has been, my lord, the allowed.
No, the counterclaim has been allowed thereby.
In part.
What has been allowed?
My lord, allowed, my lord, regarding the shares, when shares have not been.
Oh,
my lord,
both are regarding shares,
shares.
counterclaim and.
Counter- yes.
No, but
If it your lordship, my lord,
you have checked up, all have been served.
kindly check it out.
Yes, yes. So if I get it affirmed, file it during the course of the day. We are. So we'll pass the usual day, then let the final degree proceedings continue and then. Learned counsel for the petitioners submits that although the affidavit of service is otherwise prepared, the same could not be affirmed till now. First up, it is also submitted that all the respondents have been served with a copy of the application. First up, next para. Accordingly, leave is granted. Accordingly, the learned advocate for the appellant stroke petitioners is directed to file the affidavit of service during the course of the day after having it affirmed. Do it before recess. First up, next para. Since the appeal arises out of a preliminary decree of partition, whereby a part of the counterclaim declaring the shares of the parties was also allowed, we are of the opinion that the ends of justice would be subserved in the event the final degree proceedings continue, but no final decree is drawn up in the meantime. Full stop. Para. Accordingly, can 1 of 2023 is allowed, thereby directing the trial court to proceed to continue with the final degree proceedings. Full stop. However, no final decree shall be drawn up without prior leave of this court till disposal of the present appeal. Full stop. Next para. The appellant shall put in due requisites within a week from date. First up, the trial court records be called for by special messenger at the cost of the appellant, which shall also be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Push up. Liberty to the parties to mention the appeal as and when the same is made ready for hearing. Please ensure that the service is handed over to our officer. এটা affidavit of service দিলে ensure করবেন যে ঠিকঠাক ফাইলে যেন ঢোকে রিসেসের আগে দিয়ে
I file it before, my lord.
প্লিজ ডু দ্যাট
Lordship, I'm appearing.
Yes, Mr. Ordis.
That will be Lordship.
All have been served, Mr. Bhattacharya?
They have received, but it is being affirmed, my lord.
You have checked up, all have been served?
Yes, ma'am.
Very well. No, keep that with you, yes.
But
Just check up once
It
again.
will served on 4th January.
All the respondents?
All the respondents.
Very well. What is the matter? What is the application? You will file it during the course of the day, the affidavit of service.
Yes, ma'am.
Yes. Section 5.
One is section 5.
The other is stay. What is the appeal against?
Appeal against the final decree. In
Partition. Partition. Acha. Yes. Section 5. What is the delay about? 351. What is the reason, Mr. Bhattacharya?
No, my lord, 351, no.
You have stated in your prayer portion. Oh, sorry. I was wrong. Inside you have stated, Koto? Oh, 60.
Yes, ma'am.
But you have stated in your application it's inordinate. You have stated, Mr. Bhattacharya, after making an inordinate delay of 60 days. If it's inordinate, we should not condone it. Application delay is inordinate delay.
Objection.
Inordinate delay to right.
Paragraph 14 and 15, my lord, reason has been assigned.
Examination of daughter.
Yes, ma'am.
An inexperienced clerk of advocate. On the prayer of learned counsel for the petitioner, the petitioner is directed to file the affidavit of service during the course of the day. Full stop. It is submitted that due service has been effected on the respondents.
On 4th January.
On the respondent number 1 or all the respondents?
All the rest.
On the respondents, full stop, next para. Upon a perusal of the application, we find that sufficient reason for the delay in preferring the appeal has been made out in the application. So accordingly, can 1 of 2023 is allowed, thereby condoning the delay in preferring FAT number 351 of 2023. First of, there will be no orders to cost. The appeal shall now be deemed to stand registered and admitted. First of, next para. The what is the appeal against, you said? Final degree of partition.
Final degree of partition.
No execution has been levied, Mr. Bhattacharya.
Yes, and that is the can number 3, my lord. Can 3.
Why separate application for that?
Stay of execution.
Can 2 and 3 same then?
Can 2 and 3 most of the same.
No, you have sought a stay of the impugned final degree and preliminary degree.
Preliminary degree.
But you have challenged only the final degree. You cannot now reopen the preliminary degree.
Because, my lord, preliminary degree, your lordship has passed an order in the earlier occasions in connection with the order passed by the commissioner, my lord.
Very well, we'll just stay the execution now since it has been. Can 2 of 2023 and can 3 of 2024 are taken up for hearing together. Full stop. Whereas the first of such applications was merely for stay of operation of the impugned decree, the second application seeks a stay of the connected execution case. Full stop. Since execution has already been levied, it would only be appropriate, in view of the pendency of the appeal and to save the same from being rendered infructuous, that the execution case be stayed. Full stop. Accordingly, can 2 of 2023 and can 3 of 2024 are disposed of by granting stay of all further proceedings in title execution case number 28 of 2022 pending before the learned civil judge, senior division, 4th court at Alipur, district South 24 Parganas till disposal of the appeal. Full stop. There will be no orders to cost. So next para, the appellant shall deposit the requisites within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is made ready for hearing. But please ensure that the affidavit of service comes before the recess. It
as per track record, it has been served.
Number 25.
Yes.
Number 25.
And for the appellant, your lordship.
Appellant respondents, yes.
On number 1 and 2. Lordships has given us a liberty to file an affidavit in opposition on the last date. I'm praying for a week's extension to file the.
Why? Injunction application opposition, it was directed on 2nd of December, no further time. We'll proceed on the application.
Only the affirmation is
So why 1 week's time then?
3 days time, Lordship.
Do it today. The client has not come. What is the district from which he is coming?
Kolkata, it's district is Kolkata, Your Lordship. You can't just
Not as a matter of course, no.
I'm just praying for Your Lordship.
No, you have to give solid reasons for that. Give us one solid reason, we'll allow that time.
The client is not available today. Kindly gives us tomorrow, Your Lordship. Humbly praying, Your Lordship.
On the prayer of the, we are granting it. On the prayer of learned counsel for the respondent numbers 1 and 2, the time for filing affidavit in opposition is extended for a week from date. Stop. The time for reply is extended for a week thereafter. Stop. The application shall be listed for hearing on January 21, 2025 under the same heading.
Extremely grateful.
Why extremely? Yes. Next. Apparent, yes. Apparent is the petitioner. Good service affected on all.
Affected earlier also, this second time.
Good service. Yes. What is the application? Condonation. Oh, condonation was allowed previously.
This is the draft of certificate of probate of will.
You have challenged the probate degree. This is in the nature of a judgment in rem. There are severe consequences. If you stay, have you made out any case for injunction? We can grant injunction. Yes, nature character you have stated. No, what you have not stated.
Most of the all the appellants, including one respondents, they have recorded their share of the property before the DLRO concern in the year 2015. Thereafter, these appellants they did not appear before the landed court because on the.
So we'll direct the parties to maintain status quo regarding possession as well as nature character and transfer. Very good. Affidavit of service filed today be kept on record. Despite service, none appears for the respondents. Next para. The present appeal has been preferred against a probate decree. Since a prima facie case for hearing the appeal on merits has been made out, Can 2 of 2024 is allowed, thereby directing both parties, directing all the parties to maintain status quo in respect of possession, transfer, alienation, and or encumbering in favor of third parties, as well as regarding the nature and character of the property, which is the subject matter of the disputed will till disposal of the appeal. There will be no rise to cost. Stop. Next para. The appellants shall put in due requisites within a week from date. The trial court records be brought by special messenger along with the will at the cost of the appellants, which shall be deposited within a week from date as well. Next para. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate on record for the appellants. The will, upon arrival before this court, shall be kept in the custody of the learned registrar general, subject to further direction of production of the same at the time of hearing. Next para. Liberty to the parties to mention the appeal for hearing as and when the same is made so ready. Thank you.
If I appear on behalf of the appellant, Lordship, I have received the supplementary opposition to my Can 1 application.
Supplementary opposition or affidavit in opposition?
Affidavit in opposition they have filed. Also, they have filed. Also, they have served us a supplementary opposition, Lordship, in the 4th of December, Lordship. That is Saturday. Lordship, kindly allow me 1 week of time to file my reply.
Very well. Yes.
The Lordship had directed us to file an affidavit in opposition. Milord, I'm filing it. Milord, the supplementary affidavit to the affidavit, there was no such leave. Milord, what happened, Milord? This is a stay application against a Milord eviction decree. Lordship had framed a specific time limit for filing affidavit. We have filed the affidavit within that time. But what happened? We have engaged a Milord chartered valuer for ascertainment.
You got those later.
After.
Leave is granted to the respondent to file a supplementary affidavit in opposition. Full stop. No. Leave is granted only for this. Full stop. Next para. The affidavit in opposition as well as the supplementary affidavit in opposition filed today be kept on record. Stop. Next para. On the prayer of learned counsel for the appellant, comma, the time for filing affidavit in reply, comma, either composite or otherwise, comma, to the affidavit in opposition and the supplementary affidavit in opposition, comma, for a week from date. Full stop. The application shall be listed for hearing next on January 14, 2025. You can file a composite reply or a separate.
You can serve my learned friend. He has given a postal address of of Hooghly Millard.
No, where are you available here? Please go outside. When you go outside the courtroom, just give a address or the clerk of your senior or whatever where they can serve a copy. Yes.
Number 28 on behalf of the appellant, kindly praying for not to do.
Please.
Praying for not today.
Your expression is correct, but the prayer is not. What is the matter about?
This matter, Lordship, Mr. Dev Kumar Chandra is appearing for the response.
Both of you are asking for time. All the more reason we shall take up the matter. Yes, you have to be ready in the matter. Where is your brief? Why don't you have a brief?
Pass over for some time, kindly.
But you have to come prepared in the matter. You are the chamber junior of whom?
Advocate Somu Subra Roy.
He is appearing in the matter. Bring a copy of the brief. Get yourself prepared. We'll take up the matter after at 12. Adjournment till 12. Pass over. You also get prepared. 12টা পর্যন্ত adjourn. হ্যাঁ 12টার পর যখন বস you are quite senior in the profession. You take the preparation and move the matter. Mr. Who is appearing? Mr. Mukherjee? Oh. Anyway, let us hear her first. Come back at 12. Yes, next.
29, my lord.
In this matter, I'm appearing for the respondent. My lord, I had filed an opposition to the.
You have kept a beard. This was not there previous. Was it? Oh, it was there.
My lord,
I'm seeing you after a long time. Yes. What is the? You are the appellant petition.
My lord, this is my lord matrimonial suit.
Ah.
My lord, suit decreed my lord ex parte. My lord, some third person, my lord. My name is Sujata Kaur Wilku.
Achha.
I am for the wife.
Yes.
And Sujata Ghosh appeared for 2 occasions. Thereafter did not appear. No written statement was filed. Suit posted in the ex parte board and ex parte decree was passed.
You are Ghosh before your marriage?
No.
You were never Ghosh?
No, I never Ghosh. Sujata Kaur Wilku. আমি বলে দিই আমি অ্যাপিলেন্ট
Ghosh or ghost?
editor বলছেন আমি section, my lord, I have filed an opposition to the section 5 application.
Right.
বলছি
You have married in the meantime? Don't marry in the meantime.
This is the earlier occasion.
What is this?
The division bench of this honorable court directed
Supplementary affidavit?
Supplementary to the effect, my lord, the filing of my lord, the Vokalatnama, which was filed before the London trial court on behalf of defendant.
You have annexed that?
I have annexed this.
Have you given a copy to him?
Yes, ma'am.
Just now.
Just now. Then you get all the more reason. So you file a composite opposition, we'll give you 1 week?
My,
right.
But my lord, I don't find any Vakalatnama.
This is a certified copy, my lord. Sujata go just only to bring to the notice to the.
I also don't find. Where is the Vakalatnama?
This is certified copy. This is certified copy of the Vakalatnama, which was filed before the landed court below.
Well, we'll consider that. But you have to have the original with you, Mr.
Yes. No, original. This is the certified copy.
No, original certified copy.
The original.
Keep that with you.
Yes, ma'am.
When we hear the matter, you come prepared with that. A supplementary affidavit, leave is granted to the appellant petitioner to file a supplementary affidavit to the application for condonation of delay. Push up. Such supplementary affidavit, filed today in court, be kept on record, and a copy thereof is served on the learned advocate for the respondent. Push up. The time for filing a composite affidavit in opposition to the application for condonation of delay as well as the supplementary affidavit is extended for a week from date. Is granted for a week from date. Reply if any shall be granted within a reply if any shall be filed within a week thereafter. The matter shall next be listed on January 21, 2025 under the same heading.
So far, the opposition is concerned to the application under section 5 that they have filed. Only opposition to the supplementary affidavit.
Oh, তাহলে যেটা কম্পোজিট বললাম না, কম্পোজিটটা কেটে দাও আর অ্যাফিডেভিট ইন অপোজিশন টু দ্য সাপ্লিমেন্টারি অ্যাফিডেভিট। Where is your reply to the opposition?
Yes, sir, that is the one with the record. This is with the record.
They have already, you have already
Yes,
filed.
sir, that has been exchanged in course of hearing, my lord.
Very
Because
understood.
Item number 30.
Yes, Mr. Chatterjee.
Lord, your lordship sent it for mediation, my lord, but the
Failed.
parties have, my lord, started a talk of settlement.
Very good.
It should
This is
be
matrimonial.
matrimonial. My lord, so it's just a monetary thing, my lord. It should take this month. Keeps it.
Divorce was refused.
Yes.
So when should you keep it? Tell us. February month.
February month, my lord, right.
You are for the other side. You are not seriously opposing this, or vehemently opposing this, or any other shade of opposition. How unfortunate. Very well. Yes. Come back in February. Let us hope something happens. Learned senior counsel appearing for the appellant submits that although the matter had been sent to mediation, the parties have
not sent, my lord. It was directed. We prayed for it, and your lordship directed it.
আচ্ছা তাহলে এটা কেটে দাও Learned senior counsel appearing for the appellant submits that the parties are exploring options of mutual settlement of the matter between themselves either way, full stop. Next para, accordingly on the prayer of learned counsel for the parties, the matter is adjourned and shall next be placed in the monthly list of February 2022 under the same heading.
Number 31.
31, my lord, I am for the appealant. My lord,
Yes.
the previous occasion, my lord was pleased to direct affidavit in opposition from the.
Your Lordship, I am appearing on behalf of the respondent 125. Lordship, there had been a direction for filing affidavit in opposition. This is a suit for eviction of a licensee. There has been a delay in obtaining the valuer's report, which I have obtained just yesterday. I'm only praying for a short.
How much time? Tell us.
Week.
Week. Got the time. You are enjoying stay. On the pair of the respondent numbers 1 to 5, you are for 1. On the prayer of learned counsel for the respondent numbers 1 to 5, the time for filing affidavit in opposition to the application is extended for a week from date. Which of reply, if any, shall be filed within a week thereafter. The matter shall next be listed on January 22, 2025 under the same heading.
Item number 32.
Item number 32,
Yes, Mr.
my lord,
Chakravarti.
appealing for the defendant number 1 to 3.
Right.
And I'm with the appellant, my lordship, directors to service. The service has been effective, like it's not affirmed. Well, I'll just
Can get it affirmed today?
Yes, yes. During the
Please
time.
check up whether all have been served.
Well, all have been solved.
So, what is that?
This is a matter of lordship. Please to grant us an order of injunction in this matter.
But the challenge is against?
The challenge is a suit for partition, wherein in respect to
The
me.
preliminary degree you are challenging.
The preliminary case. But 72 decimals of land that has been admitted by the plaintiff himself, meaning the plaintiff. Your lordship recorded on the last order also. I have shown the plaint. Now, only I am in possession. So lordship granted us.
So you'll make this order absolute?
Yes. That
Very
is
good.
This is the affirmed copy.
Affirmed. Good. Fine. Affidavit of service filed today be kept on record. Full stop. Despite service, none appears for the respondents. Stop. The present appeal arises out of a preliminary decree of partition. Full stop. In view of sufficient prima facie case for hearing of the appeal on merits having been made out, comma, can 1 of 2024 is disposed of by making the interim order granted earlier absolute. Push up. Accordingly, the respondents shall maintain status quo with regard to possession of the suit property, as well as in respect of the nature and character, and regarding transfer, alienation, and creating encumbrances in respect of the suit property in favor of any third party till disposal of the appeal. Pushed up. The learned trial judge shall continue with the final decree proceedings, but shall not draw up any final decree without prior leave of this court, also till disposal of the appeal. No address to cost. Pushed up. Next para. The respondents have never appeared, Mr. Chakravarti, in connection before this court.
No.
So put in the requisites. The appellant shall put in requisites, necessary requisites within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Stop. Next para. The appellant shall prepare and file the necessary, the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. For sub liberty to the parties to mention the appeal for enlistment as and when the same is made ready for hearing. Thank you. Here for the respondent. Where is the appellant? Mr. Das was there on the last week.
I've received instruction, day before, it's 5 days. I need to file affidavit in opposition
To this application, what is the application? Injunction.
the observation of the decree, 3rd September. 2024.
We had granted injunction on the last occasion, probably. Anyway, so you want how much time? 1 week? Good. On the none appears for the appellant at the time of call, full stop. On the prayer of learned counsel for the respondent, comma, the respondent is directed to file affidavit in opposition to the application within a week from date and serve an advance copy of the same on the learned advocate for the appellant. Full stop, next para. The affidavit in reply, if any, shall be filed within a week thereafter. Full stop, the application shall be listed for hearing next under the same heading on January 22, 2025.
Item number 34.
Lord, I am for the petition. Happy. Lord, in terms of the previous order passed by your lordship, Lord,
Good service affected.
effected service upon the learned advocate who is appearing for the plaintiff.
He has received.
He received.
With objection or something like that? No.
No, Lord.
Check up.
We can actually take.
Just check. Just check up and tell us.
Received all copy, Mr. Debesh Ghosh, advocate. This
Very
one.
well. What is the application for?
Lord, application for stay, Lord, the appeal against the preliminary degree in a passed in a partition.
So usual order. Affidavit of service filed today be kept on record. Full stop. Despite service of notice on the learned advocate appearing for the respondent in the trial court, comma, none appears for the respondent at the time of call, full stop. Accordingly, can 1 of 2024 is taken up for hearing ex parte, full stop. Since a prima facie case for hearing the appeal on merits has been made out, comma, can 1 of 2024 is disposed of by directing the learned trial judge to continue with the final degree proceedings, full stop. However, comma, no final decree shall be drawn up till disposal of the appeal without prior leave of this court. Full stop. Next para. The appellant shall put in due requisites within a week from date. Stop. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para. The trial court shall, comma, however, comma, for the purpose of proceeding with the final degree proceedings, comma, maintain a skeletal record if necessary. Full stop. Next para. The liberty to the parties to mention the appeal for enlistment as and when the same is made ready for hearing.
Okay.
Item number 35.
Yes, please.
Every service on affirmation.
Have you checked up? All have been all delivered. Very well. Yes. Oh, only one respondent. What is the appeal against? Matrimonial. Divorce granted or refused?
What is restitution of conjugal rights?
You asked for restitution. They got a degree for restitution. Well, we will continue the state till disposal of the appeal. It is submitted by learned counsel for the appellant that the affidavit of service shall be filed during the course of the day. So it is further submitted by the learned advocate for the appellant that the that copy of the application has been duly served on the respondent. So next para, the affidavit of service shall accordingly be filed during the course of the day. Full stop. Can 1 of 2024 is disposed of by granting stay of operation of the impugned judgment and decree dated July 25, 2024, passed by the learned additional district judge, 5th court at Barasat, district North 24 Parganas, in matrimonial suit number 16 of 2019, till disposal of the appeal. Full stop. Next para, the appellant shall put in due requisites within a week from date. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for the enlistment as and when the same is made ready for hearing. But ensure that these affidavits come in. We'll come back. Password. She has to move. She has to start at least. That was the understanding. Yes. You can take up if she. Anyway, what is the matter about? Yes.
Opposite party file a grant a decree and
Opposite party filed a suit for what?
for eviction, my lord.
Eviction of tenant or licensee? Tenant. That has been decreed against you, against that you have come up. No caveat is there.
No caveat is there.
Yes, you come up. Yes. No caveat?
No caveat.
But opposition was filed.
They have appeared and we grant a stay till disposal, my lord.
No, you have to put in occupation charges.
My lord.
Fair rent, they have said 8,000 to 10,000 per month.
Moreover, it will be 800. It's a 90 square feet room with a common bathroom, my lord. Nothing more.
90 square feet.
90 square feet.
Residential.
Residential. Small room, my lord.
Have you got anything to show? Have you stated anywhere it's 90 square feet?
They also did not
State. What is the area? Location? Which area? Let us see the schedule.
Kumar Shet Lane, PS Jorabagan, Calcutta 6.
Let us see their opposition since they are not appearing.
My reply, I have stated it.
No, I will see their opposition first because they are not appearing. We have to be all the more cautious in their favor.
The learned advocate appearing for the respondent, my lord, personally informed me that he is coming or
Who is he?
Mr. Dev Kumar Chandra.
He said he is coming.
I have called him. He informed me.
He has a duty. You have come. No, it was decreed under 2G. What is your defense? What is your prima facie case? You are a son of the original tenant. 5 years elapsed.
What is the original tenant?
Wife of the original tenant. Yes. What is your ground of appeal? Let's see the memo. What is the ground on which it was decreed? 2G only. Let us see your memo. What have you said? Small cause you have taken only the jurisdiction point. Jurisdiction. Small cause court has jurisdiction. Jurisdiction to grant a decree under the 1997 Act. Does it?
Actually, my lord, Mr. Udhikar is appearing as my senior.
What was the original rent you were paying? 20. They were.
It's a moreover 800 to
No, nowadays, modern day,
90 square feet room, my lord, a residential room of 90 square feet. Only
it was a 90 square feet room in Jorabagan for 5,000 rupees, less than 5,000.
Kindly make it 1,000. Moreover 800 to 1,000.
What is the composition of your family? You and who else?
And my son, my lord.
What does your son do?
He is a student. I think. I have to take instruction on that ground.
What have you stated in your reply? You are placing your reply. One room less than 100 square. ভিডিও লেডি 2000 কি হচ্ছে 2000 কম হয়ে যাবে না কম। তবে 100 স্কোয়ার ফিট
হ্যাঁ, actual কম
90 স্কোয়ার ফিট 90 স্কোয়ার ফিট ফার্স্ট ফ্লোর 9 ফিট 10 ফিট একটা ঘর বেডরুম এখানে থাকতে পারবে কিনা একটা লোক থাকতে হবে দুজন মিলে থাকে সেখানে কি করে দেখি কাগজ বের পড়ছে What does your husband do?
He died, man.
Wife of your stated Sri. Even in a reply, no late.
It's a typographical mistake.
Even in the cost title of the main application.
It's a typographical mistake.
None appears for the opposite respondent opposite party at the time of call. Push up. Heard learned counsel for the appellant and peruse the affidavit in opposition and affidavit in reply along with the application. Push up. As per the appellant, comma, who has challenged in the appeal a decree of eviction primarily on the ground that the appellant is a trespasser within the contemplation of section 2 within bracket small g of the West Bengal Premises Tenancy Act 1997, comma. It is the case of the appellant that the premises is of about 90 square feet and is located on the first floor of an old dilapidated building at 3A, comma, Brojo Kumar Set, ACTT Lane, comma, Police Station Jorabagan, comma, Kolkata 7,06,000. Footstep, next para. In the affidavit in opposition, comma, the specific area of the premises has not been mentioned as such. Push up next para. The respondent has contended that the area is a lucrative one and no less than rupees 8,000 to 10,000 per month should be fetched if the said premises is let out at the present juncture. Push up next para. Learned counsel for the appellant submits that although inadvertently it has not been reflected in the cause title of the application or the reply, comma, the appellant is a widow lady having a son who does not have any income. Push up next para. Considering the financial circumstances of the appellant and also the fact that the suit property is less than 100 square feet and located on the first floor of an old building, comma, we are of the opinion that occupation charges of rupees 2,000 per month as condition for grant of stay shall suffice. For sub next para, accordingly, can 1 of 2024 is allowed, comma, thereby granting stay of operation of the impugned judgment and decree and stroke or any execution case, comma, if levied pursuant to the same, comma, till disposal of the appeal, comma, subject to the appellant depositing occupation charges of rupees 2,000 per month, comma, payable by the 10th day of each succeeding month. Full stop. The first of such payments, comma, for the month of January 2026, comma, shall be paid by the 10th day of February 2026 and thereafter by the 10th day of each succeeding month. Full stop. Next para. When was the decree passed? 2000. Yes. When was the decree passed? Date of decree? 24. The area occupation charges at the above rate shall be deposited by December degree, na? June, shall be deposited by 3 equal monthly installments, comma, the first of which shall be paid by January 31, 2025, and the next 2 installments by the 31st day of each succeeding month. Full stop. Next para. Subject to the payment of such current as well as arrear occupation charges, comma, the stay shall continue till disposal of the appeal. Full stop. However, comma, it is made clear that in the event of default in payment of any of the above, comma, either current or arrear occupation charges, comma, the interim order of stay shall stand automatically vacated. Full stop. Next para. The above occupation charges shall be paid directly to the respondent. Full stop. Next para. However, comma, the said payments shall be subject to final orders which might be passed at the time of disposal of the appeal. Full stop. Next para. The appellant shall now, in view of appearance of the respondent through learned advocate, comma, service of notice of the appeal is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
Lord, may I submit one? Kindly reduce the occupational charge regarding the arrear amount, my lord. Current amount is 2,000.
3 installments, monthly installments.
Kindly reduce only,
No.
my lord. I have a
2000 is nothing. We have,
But
that's why we have
regarding the
given you
arrear amount, my lord.
3 installments by the 31st of each month. Arrear is not much from last June. 3 monthly installments, not less than.
My lord, my
Thank you.
appearance.
Despite service, none appears for the respondent বলেছে ওটা কেটে affidavit service file to be kept on record. তারপর judge ফেরে
Yes, my lord, I am for the appellant, my lord.
Yes.
My lord. But service has not been, my lord, effected with endorsement, postal endorsement, my lord. Address cannot be located.
Then you have to find out the address.
The other side was present just before some times ago.
But they did not appear on the last occasion.
No, my lord. That time I have not served. As per direction of your lordship, I have served the copy.
Other side is present today.
Today, before some.
Who is appearing?
I don't know, but that time matter was called.
We are passing over. We'll take it up at 2 p.m. Inform whoever was appearing. I mean, do you know him? I mean, who was appearing?
Yes, my lord. I just seen.
You know the address or
I
phone
don't know
number?
the address. Well, I have seen that he appeared in this.
Must be Mr. Mukherjee. Yes. Trying to hide behind you. That's right. So we'll make it not today then.
No, my lord, tomorrow is appearance in the lower court because execution is already pending, my lord. My lord, address cannot be located. Whatever the address, my lord, mentioned in the plate.
No. Then we cannot pass any order.
But kindly pass over this matter for something.
Can 2, we are taking up can 2 now.
Can 2 for condonation of the delay, my lord.
This is against what judgment?
Judgment for eviction, my lord, 2G.
Stay application is also there.
Stay application can 3.
Then we'll pass it over, but otherwise you have to serve afresh.
My lord, same address. They are not residing in that address because after demise of the original plaintiff, the legal heirs is residing in different address. So if we served again, my lord, the same thing will again.
You have to look at the address, current address. We cannot proceed with the appeal hearing without. You try to look at the advocate.
I'll pass over this matter for some time.
None appears for the respondent at the time of call. Full stop. On the prayer of the learned advocate for the appellant, the matter is adjourned for the day. Try to inform him during the course of the day. We have adjourned for the day.
It will appear tomorrow.
Yes.
May I permit to mention item number 28 once again? I have made the wrong submission, my lord. For unconditional apology, my lord.
Accepted, but what is the wrong?
I have submitted that the husband of the appellant is dead. He's bedridden, my lord. It's my wrong submission.
You have killed a man.
I am praying for
But our premise was that. Then it will be 5,000.
But it's my fault, my lord. I got a wrong instruction, my lord. Right now I have
order to pass.
My wrong, sir. The other side is also there. He's bedridden. I can produce the medical document, my lord, but he's not there. It's my wrong, sir.
So, item number, what is that?
28.
28 একটুখানি বলো তো 28 কি বলেছে একটু বলো। যেগুলো বুঝতে পারছো না ছেড়ে দাও, স্কিপ করতে করতে যাও, কোনো মেন জায়গাগুলো বললি। নেক্সট সেন্টেন্স চলে মাঝখান থেকে বলে, মাঝখান থেকে ধরো, আমি ধরে নেবো। না, তার আগে কি কোথাও বলেছি যে ওই অ্যাপেলেন্ট অল দিট হ্যাজ বিন রংলি ডেসক্রাইবড, হাজবেন্ড মারা গেছে। ইন দ্য কস্ট টাইটেল অফ দ্য রংলি রিফ্লেক্টেড ইন দ্য কস্ট টাইটেল, এই কথাগুলো কি ওই সেন্টেন্স একটু বলো। হ্যাঁ, রংলি রিফ্লেক্টেড ইন দ্য কস্ট টাইটেল এখন কন্টেক্ট। Right.
So I get the other 3/5 share.
Yes, but
So then
jointly
also
with him.
similar thing. That is where
But that is the last 26 CW he cited.
I'll
There was a similar scenario.
No, I'll completely different on that. Completely different aspect. But there what happened was in the 26 CWN situation, Milord, was there that there was no problem with respect to jointness of possession. Here, Milord, there is the only problem is jointness of possession. Factually, Mr. Rai did not place the plane. That is where the problem is. The problem inter se the parties today, Milord, on a larger scale, is with respect to jointness of the possession. To mitigate this problem, Milord, first 81 deed came into play, then 96 deed came into play, then 2015 Milord deed came into play. So my basic submission before your lordship is, you are challenging the corollary by accepting the main thing. Main document 96, you have accepted it. You have not challenged it. Even if you had challenged it, the Supreme Court says that you are stopped from challenging it. You are, because you are a signatory to that document. So today, if your lordship has to say, Milord, 2015 document has to go, is invalid, forged, or whatever, Milord, the 96 document stays. So if the 96 document stays, then the mother stays, but the child goes. That is a bar under 30. Now I'll quickly take
So you mean to say that they should have challenged 96 deed also?
Absolutely.
That's why proviso comes in.
That is why the proviso comes in. Because he is challenging, Milord, the consequence and not, Milord, the problem which is the main thing. On the contrary, Milord, he has deposed that he has signed on it, he has acted upon it, and he has leased out properties. So my invocation of 34, Milord, is not basically, Milord, with respect to prayer for partition, but also, Milord, with respect to not challenging the 9060. Kindly comes directly to the plaint once. I will not take your lordship, Milord. It's just those places where, Milord, Mr. Rai has skipped, and I think it's important for your lordship to, Milord, Milord, your lordship remembers on the factual aspect, the property belonged to the father.
Yes.
Omeo. After Omeo, Milord, he had three sons and two daughters. One daughter and one wife. Wife, 3 sons and 1 daughter. Now, he accepts it. Kindly have a look at, if your lordship sees, Milord, Shri Prasad is my learned senior friend's client. Devo Prasad, Shubho Prasad and Ugni Shikha is the daughter. Because the mother passed away, Milord, and thereafter it vested, Milord, on the other. Kindly have a look at paragraph 5. Paragraph 5.
Mother gifted his.
Yes, that's why I'm showing. Paragraph 5.
Yes.
His plaint. Milord, there are 2 properties, Annabelle and Milord Shopnopuri.
Yes.
Shopnopuri, Milord, is the subject matter of the suit before your lordship.
Yes.
Kindly have a look at mother gifted some portion from Annabelle to the plaintiff, where the plaintiff constructed Banerjee Auto Service. This is his plaint case.
That gift deed has been exhibited.
That gift deed, Milord, I am not too sure, but it's an admitted document.
Very well. No, they did it demarcate portions.
Yes, sir.
Mother's share.
Not demarcate, shares. Share was given.
Okay.
And Ogni Shikha got, Milord. If your lordship sees Shushoma, yes, 11. Paragraph 11.
Yes.
Ogni Shikha, Milord, Shushoma is the mother.
Right.
She gifted, Milord, to Ogni Shikha, that's the defend number 3. Milord, a part of that, and where he says, Milord, Mohan Manzil has been, Milord, constructed. Mohan Manzil, Milord, is where Ogni Shikha has constructed her property, and Milord, I'll show how it has been dealt with, Milord, in the family section. Then, paragraph 13. That out of love and affection, Shushoma gave her 1/5 share in Shopnopuri to the plaintiff, and the plaintiff became owner of 2/5 share of Shopnopuri.
1/5 is
Because he has said, my lord, that he has given out something from his own portion and not from the gifted portion.
Hmm.
I'll take your lordship to that. He accepts that in Shopnapuri, my lord, Shushoma, the mother, gifted him, my lord, 1/5.
Hmm.
So he gets 1/5 of his own from the father
Yes.
and 1/5, my lord, by gift, my lord, from Shushoma.
Hmm.
2/5. Then kindly turns to 17. This is the acceptance, admission, which my learned senior friend doesn't, my lord, show your lordship. I interjected on the last occasion, but he stopped me.
Yes.
Kindly have a look at paragraph 17. That in the year 81, a family settlement deed, Miley marks it, was prepared amongst the heirs of Omeo, but that deed was neither registered nor acted upon, and the plaintiff, besides the share of defendant number 3, used to possess all the properties, including the suit property. So family arrangement in 81, first time he accepts. And my lord, I will show your lordship, a family arrangement doesn't require registration.
He says it was not acted upon also.
I'll show that, how that has changed, my lord, with the cross-examination. Now, so I need to show just a simple thing before your lordship that 81 was acted upon and 96 was acted upon. There's nothing beyond that I need to show your lordship. And I will not show anything beyond his admission. Now, 81, my lord kindly takes up the supplementary. My lord, there are ways of depriving the co-sharers. There are ways, and this was one of them.
The page 1, something has been highlighted that appears black in our copy. What is that sentence?
Page 1, my lord, of?
Page 1 of the supplementary paper. The first.
For the
No, on behalf of.
other defendants who are brothers.
Can you have it typed somewhere and give 2 copies to us? We shall incorporate that. Because this is not decipherable in our copy.
Lord, your lordship need not even trouble, my lords.
That is not relevant.
Because I am not even getting into our case.
Somebody highlighted it, that's why.
From plaintiff's case. I think he highlighted that for some reason. My lord, kindly turns to 13. Page 13. Lord, he has accepted this document.
Page 13 or para 13?
Page 13.
Page 13, yes.
This is a part of that 96 document.
96 document, yes.
And this is an exhibit, my lord, made by us and accepted by him.
Yes.
On admission.
But he also says in his plaint that it was not acted upon.
That is exactly what I'm trying to show, my lord. It will come out from his, my lord, cross-examination. The first, my lord, he did not, my lord, even refer to this. He accepts that there is a document, but it's not acted upon. So if there is a document and is acted upon, his case, my lord, is demolished. So first family settlement took place, my lord, in 81, where 3 sons of Omeo and his widow allotted separate portion to Ognishikha, 1/5 share in Schedule 2 property. Ognishikha thereafter. I'm sorry.
Yes, we are there.
Grateful. For her 1/5 share in Schedule 2 property, Ognishikha Banerjee thereafter made some reconstruction and constructed her residential building there, which is at present called Mohan Monzil. So 81 is acted upon. The statements made in this document below is accepted by him. Milord, Mohan Monzil was constructed by Ognishikha on the basis of that 81 document. This is the statement made in the 96 document. So acted upon by the 81 document. This itself, Milord, demolishes his case completely. And this is exactly why, Milord, Mr. Rai, Milord, did not place this before your lordship. Now, he has given your lordship an impression that 2015 is the deed by which partition is happening. No. The family arrangement happens first in 81, again in 96, and after that family arrangement happened, Milord, it was inter se between those parties, Milord, with respect to Shopnapuri, that this was, Milord, gone into. But because if you have to, Milord, now sell the properties to somebody else, then there has to be, Milord, a registration somewhere. So inter se those persons who got the property in 96, Milord, that document was made. So he has failed to show, my lord, that that's a forged document. There is no evidence. He, on the contrary, accepts that document, and he is claiming a right on the basis of that document.
He only says it was not acted upon and not registered.
Exactly.
But he says, admits that it was prepared.
Prepared and acted upon is on the basis of this document itself.
But this document he also says not acted upon. So
He has said accepted this document. He has in his cross-examination, I'll take your lordship directly to that. Kindly turns to, my lord, page 44. Crossটা বার করে দাও। 50 থেকে না 46 থেকে দেখো। My lord, in the chief itself sees page 46, paragraph 46. That I have leased out certain property of Annabelle Villa to the Indian Oil Company.
on my own portion.
On my own portion. So there had to be a demarcation. There's no evidence of that sort. Nothing.
He says that he meant shared from his in.
And to not on the basis of the family settlement deed. Yes.
He says
Then turns over. This is in chief. Then in cross starts from 49, just turns over, my lord. I'll, for the sake of continuation, my lord, last line of 49, my residence. And the residence of defendant number 3 are situated over plot number 1664. The defendant number 1 and 2 are not situated over plot number 1664. I run a petrol pump business over plot number 1664 since 2004, covering approximately 12 decimal. Beloved, what is 1664? সেটাই দেখিয়ে দিচ্ছি না property of land. Lord, what is that 1664? Lord, your lordship has to again go back to that family settlement in 1996. Have a look at page 16, schedule 2. So he is, on the basis of, my lord, this 96 document, he is possessing, and, my lord, he is constructing, and he is, my lord, going whatever he wants to on the basis of 1996.
Schedule 2 went to him as per
Yes,
this.
yes. So the entire argument, which is based on a fact that, my lord, that this is the present document and there is nothing before that, is factually incorrect. Because this 1996 document was exhibited on admission. That your lordship will find on the next page. নোট করছেন বলে আমি দাঁড়িয়ে নাই তো তারা আছে কিছু
You want the hearing to be concluded before? No, which is proper.
I have almost, I am going in a normal pace. Huh?
Yes.
I have also a car workshop over plot number 1664.
Yes.
Covering 7 decimals approximately. My residence, the petrol pump and the car working workshop are adjoining to the Ranchi Road. My residential house covers only 3 katas. Part structure of my residential building was purchased by my father and remaining of my residential building was constructed by my own fund. This is not the subject matter of the suit at all. Turns over, my lord.
Residential building is not over 1664.
Yes, my lord. Is that the other one? Absolutely.
The other person.
Yes, because he was gifted. He was gifted.
Right. Entire 1664 was gifted.
No.
You also had some part in 1664.
Yes, my lord.
All right.
My lord, I am only trying to show your lordship this,
Yes.
that on the basis of the 1996 document, he is possessing, my lord, with respect to his portion.
But he has built his residence beyond 1664.
Because he got that 2/5 share, my lord, what he said?
Mother and father both. gift deeds. Mother probably.
No, my lord, at 16, my residence, petrol pump and car workshop are adjoining to the
One
Ranchi
plot,
Court.
1664, father gifted the property to grandson, that is
No, your residence is on 1664.
1664. And
1664.
property was, the mother share was gifted just of the other property, which is the subject matter of this suit.
Shopnapuri.
Shopnapuri. That is why I claim 2/5 share.
Very well, but you have your petrol pump, your car workshop, and your residence on 1664.
Where I have 1/5
Which
share.
he got from this document, 96 document.
1664.
And my learned senior friend says father's gift. But that's not probably, my lord, even exhibited, my lord. There was nothing from the father. Something which I don't know, my lord.
Mother gifted 1/5 at least
Gifted
in
1/5.
honor bill.
Yes.
Shopnapuri.
Shopnapuri.
All right. On admission, yes.
Kindly sees the next page.
This family
This
settlement is of
document bears my signature.
96. Yes, is tendered to the.
The first, my lord, the first line is the
Yes, yes.
unregistered family
Right,
settlement deed is tendered to the witness. This document bears my signature. I put my signature on behalf of myself and defend numbers 1 and 2. This document also bears the signature of defend number 3. I delivered my consent to execute the unregistered settlement deed. Let the family settlement be marked as Exhibit A on admission. The present suit property was allotted in favor of all the defendants as per the deed of settlement. His statement. The portion of RS plot number such and such 1664 under Moja Mongudia was allotted in favor of me as per the said deed of settlement. At present, the said property is lying under Bhatbad Moja. I have been running a petrol pump over the said property on the strength of said family settlement.
So this is the acted upon part,
Yes.
which Mr. Rai virtually considered.
Exactly.
Because this is there. He
Yes.
cannot deviate
My
from
lord.
this.
And Milord remembers the plain case, which your lordship, Milord, first saw. That I am doing that not on the basis of the family settlement, but on my own portion. In cross, the truth comes out.
Therefore, Mr. Chatterjee, the position remains as per Mr. Rai that yes, it was acted upon. But since it's not a valid document as per law under section 14, therefore, title did not pass. So partition did not happen in terms of law.
The title never passed. Title was vested with them. The title was never created, Milord, by any document. The title came, Milord, from either the gift deed or, Milord, from succession. These documents did not create title. That is my...
No, title as in, because in a partition deed also, although it's not a part of the Transfer Property Act transfers, but even then it's a sort of exchange. I mean, the joint rights in a portion are transferred in favor of the other, exchanged rather. In the exchange of his joint rights in favor of my property.
So title did not pass there.
No, that's a transfer of interchange of title
This is
also.
the, Milord, arrangement between the, Milord, family members that my shares are all admitted. My shares are admitted.
But if I take a particular portion, Mr. Chatterjee, isn't there a sort of transfer in the sense that otherwise every co-owner has title over every inch of property, the usual the notion. So that inch of over the inches of property which are allocated to me by a family arrangement.
This is what the Supreme
There you have
Court
to
is-
distinguish on
yes,
judgments.
Supreme Court is on
Yes,
different
yes.
footing.
That distinction between yes. And estoppel is a very strong argument of yours, apparently.
It is. That's my argument.
Because if you agreed,
That's
then you
my
cannot
argument.
decide from that.
That is my argument. That estoppel, once you've agreed, once you've taken advantage of that, now you're stopped from even raising a question over that. And I'll show you a lot of Supreme Court.
Because otherwise, oral partition is a settled position of law, apart from section 14 angle.
Yes. Yes.
And section 14 prohibits a partition.
Partition.
And you want to distinguish between a partition and a family arrangement.
There is a difference between the two. And he was also citing judgments on if, my lord, a right is being created. Though no right is being created. The right is already there. It is, my lord, I have 4 properties. Who will take what? 4 out of the 4 properties. I am taking, my lord, this, you are taking that, and we are happy with each other. And the statements in that deed is, my lord, that I am not going to for mitigating a future, my lord, litigation. This document is executed. Lord, my learned friend wants me to show your lordship, but I don't think your lordship needs it. But even then, Page 51, facts are, your lordship has seen the facts. 51 and 53 is something that your lordship might not want to see.
53, there is no deed of gift executed by my father.
Yeah. And also that Ognishika constructed her residential house after my father's death. There is no deed of gift executed by my father in respect of plot number 166. 51 টা হচ্ছে সেটা 51 milord, you kindly looks to 51.
51, yes.
It is fact that do not reside over the suit property at present. I reside at the house named and styled as HON'BLE. So Shopon Puri milord, my learned senior friend, is shouting milord that I am in possession, I am in possession. No. He himself is saying, milord, what I am trying to show your lordship is that this 1996 document was acted upon to the T. Which my learned friend milord my learned senior friend milord did not want to milord show your lordship. He is saying as if that 96 document was never acted upon. No rights were created by that document. There was no family arrangement, and even if it was a family arrangement, then it required
Says
registration.
it was acted upon, but he says it doesn't have any force of law.
Does not have a force of law. Then section 14 is the only thing. milord.
Section 14.
So now my argument of
Ultimately boils down to section 14.
14, and it comes down my argument to Lord estoppel. And he takes up Lord 1976 first. 76(3). 76(3) SCC 1976 3 SCC 119. Lord, this is a 3 judges bench decision. Kale. Lord, kindly have a look at paragraph 9 first. The 7th. That's a 7, milord. He is very particular about 7. He's always been said 7 দেখাতেই হবে.
Very well.
7 আর 8 টা দেখাবো না? হ্যাঁ।
8 is the other side's argument.
One paragraph in 8 is important because that's on estoppel.
Very well.
7, milord, kindly allows me to place it for your lordship's kind consideration. In support of the appeal, Mr. Garg, appearing for the appellant, submitted 2 points of law before us. In the first place, he argued that the grounds on which the courts below have not given effect to the family arrangement arrived at between the parties in 1956, culminating in the mutation in 1957, are not legally sustainable. The High Court took an erroneous view of the law in rejecting the compromise on the ground that it was not registered. It was argued that an oral family arrangement had already taken place earlier, and a petition before the Naib Tahsildar was merely for the information of the court for the purpose of mutation of the names of the parties in pursuance of the compromise, and therefore no question of registration of the compromise in this case arose. Secondly, it was contended that even if the compromise was unregistered, it would undoubtedly operate as a clear estoppel against the respondent numbers 4 and 5, who, having taken benefit thereunder and having remained in possession of the lands for more than 7 years, cannot be allowed to revoke the compromise. This was the argument, paragraph 8. Kindly have a look at 6. The doctrine of estoppel would not apply because the family arrangement being compulsorily registrable, there can be no estoppel against the statute. This was also the consideration. No. This is my learned senior friend's argument. Have a look at 9. Before dealing with the respective contentions put forward by the parties, we would like to discuss in general the effect and value of family arrangements entered into between the parties with a view to resolving disputes once and for all. By virtue of a family settlement or arrangement, members of a family descending from a common ancestor or a near relation seek to sink the differences and disputes, settle and resolve their conflicting claims or disputed titles once for all in order to buy peace of mind and bring about complete harmony and goodwill in the family. The family arrangements are governed by a special equity. This is what I am on. By a special equity peculiar to themselves and would be enforced if honestly made. in this connection, my lord, enforced if honestly made. So 1996 document he has accepted, honestly made. In this connection, Kerr, in his valuable treatise, Kerr on fraud, makes the family following pertinent observations regarding the nature of the family arrangements which may be extracted thus. The principles which apply to the case of ordinary compromise between strangers do not equally apply to the case of compromises in the nature of family arrangements. Family arrangements are governed by a special equity peculiar to themselves and will be enforced to honestly, if honestly made, although they have not been meant as a compromise, but have proceeded from an error of all parties, originating in mistake or ignorance of fact as to what their rights actually are, or of the points on which their rights actually depend. So this is where, my lord, section 14 might come into play, because your lordship was saying, my lord, that a right is not being created. So a document which is made dehors of what their rights actually are.
So this is a
is
very
also
strong,
enforceable.
very strong. Kerr is very strong because it says that enforced if honestly made, although they may not have been meant as a compromise,
Exactly.
but have proceeded from an error of all parties originating in mistake or ignorance of fact.
Absolutely.
Not ignorance of law though, but ignorance of fact.
Exactly.
Because
So it takes it to a different level.
takes it at least one notch higher. I
Higher.
mean, yes.
Higher. Because it says, my lord, that what happens within the family
Yes.
should remain within the family. My lord, now what the Supreme Court is saying. The object of the arrangement is to protect the family from long-drawn litigation or perpetual strifes which mar the unity and solidarity of the family and create hatred and bad blood between the various members of the family. Today, when we are striving to build up an egalitarian society and are trying for a complete reconstruction of the society to maintain and uphold the unity and homogeneity of the family, which ultimately results in the unification of the society and therefore of the entire country, is the prime need of the hour. A family arrangement by which the property is equitably divided between the various contenders so as to achieve an equal distribution of wealth instead of concentrating the same in the hands of a few is undoubtedly a milestone in the administration of social justice. That is why the term family has to be understood in a wider sense so as to include within its fold not only close relations or legal heirs, but in our case, it's only legal heirs. There's very close relations, brothers and sisters. But even those persons who may have some sort of antecedent title, so he brings in, my lord, outsiders as well into this realm. A semblance of a claim, or even if they have a spes successionis, so that the future disputes are sealed forever, and the family, instead of fighting claims inter se and wasting time, money, and energy on such fruitless or futile litigation, is able to devote its attention to more constructive work in the larger interests of the country. The courts have, this is the Justice Krishna. The courts have therefore leaned in favor of upholding a family arrangement.
No, this is not Justice Krishna. This is
This
Justice
was by Fazal Ali.
Justice Fazal Ali. Because the language, when I saw the language, I went back and saw could not have been Justice Krishna. So easy English for so long. I mean, intolerable for Justice Krishna to go on so long on normal English.
But that's very true. Milord. But what I say, Milord, the thought process was at
Yes,
that point,
thought process was absolutely at that point, which is now under dispute, rather varied from by Justice by ex-chief CJI, and the other judges they differed. 3 judges differed, including Justice Dotto.
Yes. This is
Yes.
that Aligarh University.
Yes. They differed. They differed on the views of Krishna being.
There were various. Milord,
Justice Krishna was the flashpoint.
He came out with that, Milord, nipped in the bud and
Nipped in the bud, yes. But ex-CJI differed from Justice Krishna, holding it to be obsolete, sort of. Justice Sudhanshu Dhulia and 2 other judges, Justice Dotto and.
Yes, Milord, and lady.
Exactly. Yes, Justice Nagaratna. They differed. And Justice Nagaratna and Justice Dhulia were very strong. Anyway.
But reports were something else, but they said that probably not consulted.
No, that was Justice Dotto only. Justice Dotto, as usual, I mean, he was not consulted. But the other 2, they were on the socialist aspect also. Those social views, yes. Justice Dhulia also.
Basically, that assumption and ultimately when it has been removed from this.
Again, it needs to be looked into.
Yes, but Mr. Chatterjee, on the same line of reasoning, I mean, this glorious halo given to the family probably has become also somewhat obsolete in today's world. But yes, precedent.
I am on stop. I am not on saying that there is a mistake of law. You have taken advantage of that
No,
document.
but even then we cannot hold that. I mean, family has become obsolete in certain contexts, yes. But this does not require to be, we don't have the power as high courts or even the Supreme Court probably.
Even if your lordship is not agreeable on.
No, there is no such strong, stark social change which might prompt us or even the Supreme Court now to change this view of family.
Stark changes have happened in the marriage part.
Matrimonial, yes. Matrimonial ritual breakdown has now come to, and living together also is coming soon. I mean, it should come into the statute book also.
With the present dispensation.
Yes, true, but
The thing is that the earlier.
but dispensations, Mr. Chatterjee, have to evolve themselves if they're to survive. Darwin, basic Darwin,
Which is it?
basic Darwin.
I'm not too sure on that.
Then very well, at least Richard Dawkins. I modernize it a bit, but even then, I mean, the selfish gene has to survive.
Yes, that's true. Number one.
So they'll find out ways.
If your lordship looks to India's history, Lord, your lordship, we were never driven by Lord all this. Never driven by all this.
Could not imagine.
One country. Our culture, my lord, is not one. That's the problem with the Uniform Civil Code.
Cannot be. Yes, exactly.
Cannot have.
Exactly.
We
How
were
can
a
you?
conglomeration of states. We don't have one
And that
country.
is our unique selling point. That we are that. There cannot be one language, one nothing.
Lord, I can't
One
understand
culture,
when I
one
go to my
religion, one language. Impossible.
I can't understand the language, the Bengali language when I go to my district. It's a different dialect altogether.
Exactly.
So uniformity, my lord, we only unify, my lord, when India plays cricket or when something else happens.
And
But
it's,
other
it's
things, my lord,
it will be an eyewash. Whatever we do, even we are translating judgments, Mr. Chatterjee, just imagine a translation, a Bengali judgment of the High Court being challenged before the Supreme Court. I mean, let it be decided by Supreme Court then, by someone from the northern part of or southern part of India, if it's in Bengali. Let us pass judgments in Bengali. I mean, it's not a tenable idea.
And the effect and cannot happen. It is, my lord,
Very difficult.
against the principles of India, my lord, per se.
Absolutely. Whatever we stand for.
Absolutely. Per se, it's again. I can't be forced to, my lord, have a cultural, my lord, whatever of a.
And Mr. Chatterjee, even if you, without going by personal beliefs, all of us may belong to a certain part of the country, we may have a belief. But even going by the rhetoric, the original rhetoric of the religion which you are trying to espouse, I mean, just look at the original rhetoric. It's not a religion at all. How can it be?
Mr.
I mean, we should not. I mean, this is not just. This is utterly not even obiter. But even then, you cannot be. Look at the original rhetoric then of the religion you are trying to espouse. Yes. No, but yes.
Yes, Willard, I completely bow down on that. And a lot of questions are not being asked and a lot of discussions
Yes.
on television. But the main thing, Willard, what happens is they don't realize that we were never a country by itself. We were, Willard, unification of princely state.
But the complicity which we are seeing nowadays in the institutions, Mr. Chatterjee, is very alarming. And I'm taking responsibility for the statement which is being live streamed. The complicity is very alarming of all institutions. Not only India-wide, even state-wise, everywhere. So whatever you do, you have to be enemy of the people like Ibsen to stand for your point. I mean, anyway, let us come to Justice Fazal Ali.
We'll come
Yes.
back to that, Willard, in
In a different place.
another situation.
After my retirement, when I'm 62. Yes. Yes, Mr.
Or 65.
No, that's why I insisted 62.
Yeah, I said 62. Willard, or 65. It's
At least someone.
my lord's hand.
No, not in anybody's.
It is not in. It is written here. If it is there, it's there. If
Yes.
not, nothing in this world.
Agony prolonged.
Ah.
Yes, Mr. Chatterjee, let us.
Fine.
Yes.
Then the courts have therefore leaned in favor of upholding a family arrangement instead of disturbing the same on technical or trivial grounds.
But that is where Mr. Rai may have a point.
No,
Because this is not a technical or trivial point. It's against the law.
It's against the
But
law.
this is, we cannot call out.
My lord, not just
Yes.
that. I'll show you the other paragraphs
Yes.
will come in. What I am trying to say is, even if it is wrong, you have acted upon it, so you are stopped from raising
Yes,
this point.
yes. Get you.
And especially there when you have not challenged the 1996 document.
Yes, that is there.
My lord, that is my main.
That is there. That is there.
Where the courts find that the family arrangement suffers from a legal lacuna or a formal defect, the rule of estoppel is pressed into.
This is your sentence, actually.
It's my sentence. Lord, I am stressing on suffers from a legal lacuna.
Yes, yes, exactly.
Just to, my lord, call out, rather answer my learned
Yes.
senior friend's point. Or a formal defect, the rule of estoppel is pressed into service and is applied to shut out plea of the person who, being a party to a family arrangement, seeks to unsettle a settled dispute and claims to revoke the family arrangement under which he has himself enjoyed some material benefit. I am on this. The law in England on this point is almost the same, my lord. It has been said, and then what is a family arrangement, my lord? It has been described. Your lordship need not trouble my lord self. Kindly have a look at paragraph 10, subparagraph 5.
Yes.
The members who may be parties to the family arrangement must have some antecedent title, claim, or interest, even a possible claim in the property which is acknowledged by the parties to the settlement. Even if one of the parties to the settlement has no title, but under the arrangement the other party relinquishes all its claim or titles in favor of such a person and acknowledges him to be the sole owner, then the antecedent title must be assumed and the family arrangement will be upheld, and the courts will find no difficulty in giving assent to the same. So, my lord, a person title is being created by that.
Yes, whatever has been held otherwise by the Supreme Court consistently is given a go-by for family arrangements. It has been protected, given a cocoon of, in a cocoon of
Sanctity behind it. equity
sanctity,
behind it.
yes.
There's a sanctity, my lord, between people within the family.
The cocoon of a sanctity.
Now, what happens is,
Yes.
if there was somebody else who was not a party to the family, and he was trying to, my lord, come in, my lord, by way
Create a
of
title.
creating a title,
Right,
what
right.
my learned senior friend says was absolutely correct.
So antecedent title is important. All of you had antecedent title, which is admitted.
Admitted.
Correct.
Admitted. Lord, now kindly once have a look at all the judgments were then referred to, my lord. Kindly have a look at paragraph 24. Lord, 20, it was the Allahabad High Court had gone into it. 24, my lord, is a little important. This court has also clearly laid down that the family arrangement being binding on the parties to the arrangement clearly operates as an estoppel so as to preclude any of the parties who have taken advantage under the agreement from revoking or challenging the same. Revoking or challenging the same. We shall deal with this point a little later when we consider the arguments of the respondents on the question of estoppel. In the light of the decisions indicated above, we shall now try to apply the principles laid down by this court and other courts to the facts of the present case. Now, present case, your lordship need not trouble yourself. Kindly comes to paragraph 38. Just for the sake of I'll place the entire paragraph, but just for the sake of continuity. Rebutting, Malaskani got it.
Got it. Yes.
Rebutting the arguments of the learned counsel for the appellant, Mr. Sharma for the respondents contended that no question of estoppel would arise in the instant case inasmuch as if the document was to be compulsorily registrable, marks this. Compulsorily registrable, there can be no estoppel against the statute. In the first place, in view of the fact that the family arrangement was oral and the mutation petition was merely filed before the Court of Assistant Commissioner for Information and for mutation in pursuance of the compromise, the document was not required to be registered. Therefore, the principle that there is no estoppel against the statute does not apply to the present case. Assuming, however, that the said document was compulsorily registrable, the courts have generally held that a family arrangement being binding on the parties to it would operate as an estoppel by preventing the parties, after having taken advantage under the arrangement, to resile from the same or try to revoke it. Here, my lord, is a unique situation where he has not paid for revocation of that family settlement. He is saying that the other document, which is an outcome of that family settlement, that is bad. So if the mother is good, the child is good as well.
He could not have challenged that on the ground of estoppel, even if it legally did not pass any title, he could not challenge that. And your rights of 2015 the document flow from that. So therefore, in the absence of a challenge, they cannot reopen this issue at all. Fair. Yes.
This
Fair.
is what it is.
Fair.
Lord, your lordship has summed up, Lord, my submission. I need not even trouble your lordship, Lord, any further. There are few judgments which go on similar lines, but a little bit, Lord. বইটা দে আমার আছে বই আচ্ছাকে একটা বই দিয়ে দেন তো আচ্ছা দেখতে পারো
সেটা দেখিয়ে দেবে
9.4 and 9.4. And it comes directly to 5.4 at 413. Citation the bullet. 19 volume 6 কালকে পাঠিয়ে দিয়েছো চারশো না Lord Kalia was referred to here, my lord, in 5.4. Whether on Sir Mukherjee's insistence, have a look at 5.2 as well, my lord. It's fine. The facts are all similar. If he wants to say, my lord, even if it requires compulsorily raised, it is compulsorily raised, my lord. What happens then?
5.2 is irrelevant.
Yes. 5.4 is with respect to Kalia. Then Kylie comes directly to 9 point. 9.4. 9.4. It is required to be, Malas Kali got it.
Yes.
It is required to be noted that the deed dated such and such under which the suit property had gone or devolved in favor of Krishnappa was reduced in writing before the Panchayat and Panchas, and the same was signed by the village people or Panchayat people and all the members of the family, including even the plaintiff. Though the plaintiff disputed that the partition was not reduced in writing in the form of Exhibit D4, on considering the entire evidence on record and even the deposition of the plaintiff, he has specifically admitted that the oral partition had taken place in the year 71. He has also admitted that he has got the share which tallies with the document dated such and such. Execution of the document or partition has been established and proved by examining different witnesses. The High Court has refused to look into the said document and to consider the said document solely on the ground that it requires registration and therefore as it is unregistered, the same cannot be looked into. However, as observed by this court in Calais, that such a family settlement, though not registered, would operate as a complete estoppel against the parties to such a family settlement. In the aforesaid decision, this court considered its earlier decision in such and such. That's the 1973 too, your lordship need not bother. Equitable principles such as estoppel, election, family settlement are not mere technical rules of evidence. They have an important purpose to serve in administration of justice. The ultimate aim of the law is to secure justice. In the recent times, in order to render justice between the parties, courts have been liberally relying on those principles. We would hesitate to narrow down their scope. As observed in such and such, if a person having full knowledge of his right as a possible reversioner enters into a transaction which settles his claim as well as the claim of the opponents at the relevant time, he cannot be permitted to go back on that agreement when reversion actually falls open. As held by the court in such and such, even without registration, a written document of family settlement can be used as corroborative evidence as explaining the arrangement made thereunder and conduct of the party. In the present case, as observed herein above, even the plaintiff has also categorically admitted that the oral partition had taken place, and he also admitted that 3 to 4 Panchayat people were also present. However, according to him, the same was not reduced in writing. Therefore, even accepting the case of the plaintiff that there was an oral partition on such and such the document to which he is also the signatory and all other family members are signatory can be said to be a list of properties partitioned. Everybody got right or share as per the oral partition or partition. Therefore, the same even can be used as corroborative evidence as explaining the arrangement made thereunder and conduct of the parties. Therefore, in the facts and circumstances of the case, the High Court has committed grave manifest error in not looking into and or considering the document exhibit. Lord, I cited this only to say, my Lord, even if it is compulsorily registrable, if not done, Lord, a family arrangement is still satisfied. We can multiply করে লাভ আছে relinquishment করতে তো বুঝতে না তো এটা করেন Lord, though your lordship, Lord, doesn't like being biased towards my lord's own decision, there is one decision which is
If there is any point which is not covered by the other decisions, only then cite.
Honor, my lord, this was a situation where, my lord, the Salt Lake property, many
Yes, yes.
on one day, that's a 2022 SCC online Calcutta 2385. 46.
But this is not binding on this court also.
No,
Apart from being enamored by the name. Single judge. Persuasive value. This for what proposition, Mr. Chatterjee?
For estoppel, kindly have a look at this. The plaintiffs having admitted.
Which para?
Paragraph 46. The plaintiffs having admittedly intended to transfer the property in favor of the defendants and entering into as many as 5 documents on the same date, that is August 13, 1993, it is clear that the plaintiffs gave out the intention to transfer the property in favor of the defendants. Not stopping there, the plaintiffs admittedly took a substantial amount of consideration, not less than 3 lakhs for the intended transfer, and delivered possession to the defendants. Hence, the plaintiffs are squarely bound by the doctrine of estoppel from resiling from the original intention to transfer the property in favor of the defendants, although there might have been a contractual restriction enforceable by the government against the plaintiffs. Legally, my lord, a separate aspect, but he is estoppel. Lord, my submissions are, my lord, taking into account every aspect of them. He cannot say that the 1996 document is a bad document. He tried to say that this has not been acted upon, but in cross-examination goes on to, my lord, admit that that was acted upon, and he himself got the benefits out of that document. বললাম তো আচ্ছা ঠিক আছে আচ্ছা আচ্ছা ঠিক আছে ঠিক আছে আচ্ছা দেখি my lord, quickly, my lord, if your lordship sees our document, which is under the 2015 document, kindly looks to, my lord, page 3 of part 2. Have a look at just that place, that this is only because of that executed because of that 1996 document. Lord, kindly have a look at first page 7. The gift deed, my lord, is given of 86. Mohan Monjil comes into play, my lord, in the first paragraph itself. That's the 81 document which has been talked about. Then comes, my lord, the deed of gift with respect to Shopnapuri. Then, my lord, your lordship will find page 8, third paragraph. I'm sorry, I'm grateful, man. 96, your lordship sees, that's the 90,
yes, that deed has.
Document. And the third paragraph is that this document is being executed only because of that 96 document. And everything, my lord, is there, which says why, my lord, he is not a party to this document. Why he should not be a party to, my lord, to this document. And if he claims a share, that's a unity, my lord, But he has his
So
whatever.
he
level.
challenges this also on the ground that he's not a party here.
Yes. And why he is not supposed to be a party, my lord, that's also there in the document, because in the 96 document, the rights who will get what was divided.
This is your part of the part of the rest of the.
Absolutely. So he is not a party to this document, but he is a party to the
So
document.
his premise that he's not a party is that it was never partitioned. That is the premise. He brings in HON'BLE also within the hodgepodge. And Mr. Chatterjee, you are citing further judgments.
No, I am not citing.
You'll have to distinguish.
There is just one thing.
Yes,
point.
yes.
He is not bringing in the other properties.
No, he has a counterclaim regarding partition.
Counterclaim is our counterclaim.
Oh, your counterclaim, right.
Not his. His suit, he has got nothing to do.
Your
with-
counterclaim has nothing in it. It's a backlash.
Not even. I'm not.
Yes.
Should not have been even filed. I don't even get into that. But he has not brought in the other properties. He only says that Shopnopuri, Shopunpuri or
Yes, yes.
Paragraph 10, page 10 sees the schedule of the property. The property which is mentioned is Shopunpuri. Your lordship will find. Your lordship wanted me to distinguish one judgment.
Yes, Judge. Justice Pasay's judgment 2009 to SCC 105.
2009 to.
That was cited by Mr. Rai.
The other judgment which he cited is in my favor.
That you will argue, but
Yes.
before that, because it's on squarely on your point. Here, because those other judgments you are citing, Kale and all, those are general, but this is specifically on section 14.
Yes, sir.
And Kale, although Kale is a 3-judge bench judgment and this is 2-judge bench,
Yes.
we'll have to look into, probably this does not consider Kale.
Can you see the exactly? Number one. Number two, my lord. This is where a document was being created for partition. Have a look at it. Kindly have a look at paragraph 10. As rightly contended by learned counsel for the appellant, there was specific averment in the plaint as regards the partition referred to RSROR. Though there was no date of partition indicated, a reference was made to the aforesaid document. The High Court, after having noted that none of the parties made any endeavor to ascertain when the actual alleged partition took place, came to an abrupt conclusion, and from the facts and circumstances, it was clear that the partition, if any, did not take place prior to the introduction of section 14. The basis for coming to such a conclusion is not clear.
Here, there was no question of any family arrangement or anything of that sort. There was nothing.
Nothing. They did not know when the partition happened. And it was remanded back, my lord, for the High Court to decide. And Kale was never, my lord, even looked in, which is a 3-judge bench. Here, my lord, admittedly, my lord, they wanted a partition. Admittedly, here, in this situation. My lord, kindly have a look at that 2019 judgment that my learned senior friend cited.
Yes.
No. 1915.
No. 2022 2 judgments were cited. 2017 was cited. That was this court. Our court. But 2017 is also there, Calcutta High Court Division Bench.
2215 today? 22.3 or 22.15?
Yes.
Have a look at paragraph 14 of that judgment. 22.15, page 475.
Yes. And remember to distinguish Karthik Chandra Mondal also, division bench of, sorry, not Karthik, division bench of our Justice Jyotima Bhattacharya is there. Nojrul Islam.
বিদ্যুৎ ব্যানার্জি যেটা করেছিল
Yes, that is the one.
I'll do
Nojrul Islam.
yes. First sees me this job.
Yes, 2215.
Paragraph 14. Nana Kaka.
Kale was considered.
Yes, Kale was considered and what was said. Have a look at 14. There is a long line of judgments, Your Lordship, Lord. The Kale was.
Kale is just reiterated.
Piece 15. In the facts of this case, the contention of the appellants is that Harun Nama, dated Sansar, merely sets out the arrangement arrived at between the brothers, which is a family arrangement, and it was a mere record of the past transaction and therefore by itself did not create or extinguish any right over removable property. Resultantly, the document did not attract section 17(1)(b). In other words, it is contended that even if there is relinquishment of rights by the family member, since the document is only a record of what has already happened in the past, the law did not mandate registration.
That is the argument.
No, this is the
No.
of the findings.
It is contended. In other words, it is contended that even if this begins with
And then
15, in facts of this case, the contention of the appellants is that. And the next sentence also, in other words, it is contended that. So that is a contention. Yes.
23, my lord, it says, no doubt in the said case, the court has followed the judgment. It found that the unregistered memorandum could be used for collateral purpose within the meaning of 49 of the Registration Act, subject to payment of penalty and stamp duty. That's one aspect. Then, my lord, 49C was referred to. Analysis 27. What was being considered? The proviso carves out two exceptions. We are only concerned in this case with only one of them, and that is contained in the last limb of the proviso. The unregistered document can be used as evidence of any collateral transaction. This is, however, subject to the condition that the said collateral transaction should not itself be one which must be effected by a registered document. It is this expression contained in the proviso which leads us to ask the question as to what would constitute a collateral transaction. This was the subject matter, my lord, of the Supreme Court case. If it were collateral transaction, then an unregistered document can indeed be used as evidence to prove the same. Would possession being enjoyed or the nature of possession on the basis of the unregistered document be a transaction? And further, would be a collateral transaction? We pose this question as to the contention of the appellants is that even if the Kharur-Nama dated such cannot be used as evidence to prove the factum of relinquishment of right which took place in the past, the Kharur-Nama can be looked into to prove the conduct of the parties and the nature of the possession which was enjoyed by the parties. The conclusion is, my lord, is what we have said, my lord, all through.
36
Then 36. Absolutely. If we apply the, my lord, my learned senior friend wants to rely, the test as to whether the Kharur-Nama in this case by itself affects, by itself, is the difference. Creates, declares, limits, or extinguishes rights in the immovable properties in question, or whether it merely refers to what the appellants allege to a past transaction which have been entered into by the parties, then going by the words used in the document, they indicate that the words are intended to refer to the arrangements already which the parties made in the past. The document does not purport by itself create, declare, assign, extinguish, or limit rights in the properties. Thus, the Kharur-Nama may not attract 49A. This is in my favor.
Why do you say that? You say that the 2015 document recorded 96.
96.
Past was 96.
First was 81.
81.
96, 25. This is why, my lord, Mr. Rai completely, my lord, obliterated line.
He might have been correct if 1996 was the document regarding which this declaration was sought. Then this would have squarely applied because this considers Kale also.
And the plain case is saying that the 96 is a family arrangement and takes into account 81 as well and says not active.
Yes.
So, my lord, even if your lordship sees from the equity part, a person who has enjoyed everything, my lord, just because, my lord, my clients are not around, my lord, here in Purulia, that is why, my lord, he wants to capture the entire property and, my lord, enjoy everything. This is where, my lord, the equity also comes into play, my lord, that your lordship would not even grant a semblance of a right to Mr. Rice.
And Justice Bhattacharya, division.
Same, the other judgment which he has relied upon also brings in the same thing.
So there you are relying on the distinction between 2015 and 1996 because he is now challenging 2015 and you said 1996 was the past arrangement.
81 was the first arrangement, 96
81.
recorded it, and 2015 is the outcome of that. Nothing beyond.
Really?
But Mr. our senior.
Yes.
Again, factually, very different.
What is this?
Justice Bhattacharya's judgment.
Yes, but there also same principle was upheld that section 14 comes in. Even if you take that proposition.
Partition was being effected then.
Yes.
Factually, my lord.
But that family arrangement cannot, should be exempt from legal bars also. That has been diluted by the subsequent judgments.
Not even those
First
judgments.
Justice Pasa's judgment and.
Justice Pasha never took into consideration Kale's judgment.
No, right.
That is a 3 judges bench decision, my lord. Did not even.
But 2022-15 did.
2015 did and relied on it. Did not, my lord, say something different from Kale.
No, but then your argument that Kale, I mean, no, Kale was just considered. Kale was not
considered, was never diluted. Yes, my lord, my culmination of Kale, my lord, was with respect to estoppel. That part was never touched by any of the Supreme Court decisions. My lord, whether it is compulsorily registrable or not, and then, my lord, the question of estoppel as to a person who has taken advantage of an earlier document.
What was the document in consideration in this 22-15?
Was a partition which was happening then.
Yes.
Was a partition which was happening then.
You are lucky that they have not challenged the 1996 deal.
They did not.
You are lucky in that.
Now, estoppel would have come into that would have been a larger argument.
But then, if they had challenged 1996, then your reliance of Kale would have been diluted by 22. Because Kale was considered and.
Bowed. I bowed.
Yes, Mr. Rai.
And can I turn to page 14 of the deed of settlement once because it is the argument which has supplementary payer book. Because it is the argument which has past transaction has been recorded in 1996, so it does not require any registration. 1981, according to them, that was the first family settlement.
That was one of the arguments.
That is the one of the name of the argument. Now, I can turn page 14.
14?
No, because you have said that's why
Yes.
it has already argued.
What do you say? What is your answer to that?
Whereas the avoiding further disputes, litigation and for maintaining peace in the family, the parties here to make the settlement and they are all irrevocably bound with the following terms and conditions. The first party, the eldest son of the last Tomio Banerjee, will get such and such. The second party, the son Omio Kumar Banerjee, will get such and such.
From this date?
From this date.
Mr. Rai, frankly speaking, this Kale has been somewhat diluted by 22-15 and also Justice Pasad not so much. He's right, Mr. Chatterjee. 22-15 is a very strong argument in favor, where Kale was considered.
22-3 Kale considered.
22-15 both considers Kale and
Ultimately, what might not even logically consider 22-3 once.
Yes.
Paragraph 36. Kale was considered by not evaluationally considered. And ultimately, what was held? Next page. No. 36. No, it is 22.3. 36, paragraph 36, my lord will find that the Kale has been considered.
Yes.
And
How was it overcome? By the
now,
court?
my lord, can you turn to page, paragraph 44 onwards.
Yes.
And ultimately, what was held, my lord, if you logically consider? (45) Manner arrangement to divide property in future by metes and bounds and distinguished from the actual deed of partition, under which there is not only a severance of status but also division of joint family properties by metes and bounds.
Difficulty, Mr. Rai, yes, you are right. It has, but difficulty here, do you know the difficulty?
Consider.
No, the difficulty is now how far Kale has been overruled by these,
Kale, what?
or even diluted. Both of these consider Kale. It's a well settled principle of precedents that if a judgment is considered and a contrary view is taken by either expanding or diluting, yes, the latter view may prevail. But both of these judgments quote Kale, but do not deal with that proposition vis-a-vis family arrangement, but come to a contrary conclusion. And it's very difficult for this court to say that it's par incuriam.
Now, my lord, if you logically consider the Kale, once, my lord, the section 14 was not been considered, what is the actual?
Section 14 is a different aspect altogether.
Section 14. 17, my lord, 17, which is Kale said, my lord, if you logically
Section 17 is also a legal bar, and it was considered.
That is what, my lord, the legal bar, if you logically consider section 17 once, Registration Act.
By virtue of section 49 probably, or 47 or 49 of the Registration Act.
49.
It relates back to the date of
43.
No, not 43. Either 47 or 49. It relates back to the date of the execution of the document.
43 subject to question.
Registration Act. 47.
Effect of non-registration is 49.
49.
Effect of 49, but relates back to the transfer date 43. This is what it is.
আমি একটা লিস্ট করে পাঠিয়ে
No, my lord, not 43.
What is 47? Just read once.
Yes, my lord. 47
Registration
operates.
That is what we are saying.
A registered document shall operate from the time which it would be commenced to operate if no registration thereof had been required to be made or.
So therefore, whenever registration is made,
it will,
title is finalized, but it operates from the date of the execution. So what happens? Registration gives a seal to that title passage.
Yes, my lord.
If that be so, then why is it not on an equal footing as section 14? Because section 14 says that no valid partition would be effected unless it is by, what is the language of section 14? Read once again. No partition does not mean no. I can always execute a partition deed. But the crux of it is that the effect of the section 14 is that no valid partition would be entered into without a registered deed.
Partition of a plot amongst the kosher wrath owing the same shall be made either by a registered instrument or a degree or order of a court. When partition is effected by instrument, the registering officer, these are the registering portion.
This section 14.
Yes.
Yes. What does it say?
Yes. When the partition is effected by an instrument, the registering officer shall not accept for registration of any such instrument unless there is tendered, along with it, the notice given the particulars of the plot of land and the area of each share and such.
That's different.
That is different. Now, can you come to 6, which is inserted?
Yes.
Subsequently, notwithstanding anything contained in any other law for the time being in force, or any agreement, or any custom or usage or any decree, judgment or award of any court, no partition.
So judgment or award of any court includes Supreme Court, you say?
It-
No, maybe because
Maybe.
141 lends a binding effect. It's a law of the country.
And this special notwithstanding, my lord, clause has been effected in a special act. My lord, kindly consider because it will the
Can a state statute do that?
my lord, Kale, if your
Particular
lordship,
judgment of the Supreme Court. I'm not sure. Maybe can do.
my lord,
Judgment of any court is used.
yes.
If judgment of any court is used, then all go. Kale goes.
My lord, if your
Yes, what
lordship-
is what?
Yes,
Please
sir.
continue.
Any court, no partition amongst co-sharers of a riot in a plot of land and co-partitioners of no partition amongst co-sharers of a riot in a plot of land and co-partitioners of Hindu undivided family governed under claiming to govern under Mediation school of Idullah shall have any force unless such partition is made registered instrument or by a degree or order of a court and is effected by metes and bounds, and both the conditions having fulfilled, any such partition shall be deemed to have come into force from the date of registration. My lord, 47 has also been taken into consideration. Not will give in retrospective effect from the date of execution of the deed of partition or the date of final degree.
Yes.
Now, if you logically consider section 17 of the Registration Act, if that be so, my lord, if you logically consider in Supreme judgment, in Justice Kale's judgment, your lordship find
Not
that-
Justice Kale.
as his lordship. Fazal Ali.
Kale was a
Fazal
poor
Ali.
litigant who has become
I
immortal.
agree, kind of-
Immortal.
I agree, kind
Now
of-
become more immortal due to your usage of.
হয়ে গেছে। Now, আমার কাছে-
It's a right. There is a very difficult situation here because here the subsequent two judgments of Supreme Court, Justice Nageshwar Rao 22-3 and 22 the 22 judgments, 2022 judgments. Both the 2022 judgments do what? They record Kale, but they leave it at that. They do not distinguish Kale or dilute Kale in any manner, but go on to hold the contrary.
if you logically consider,
But go on to hold that a family arrangement in respect of that what Karkunnama or something like that. Karkunnama.
yes, my lord,
But that is a family arrangement basically.
that is a earlier transaction reduced in writing, Karunama, subject to correction, my lord. That is ultimately it was held. If you logically consider, page
Yes, but the
page
but
775.
these judgments bypass the proposition which was laid down in Kale that even if there is a present transfer by you of a joint family arrangement. Yes, if they previously they had antecedent title, that is the language used. They had the antecedent title here is undisputed in your case also. They had antecedent title, they can by way of family arrangement do that. They can, I mean, there's a distinction between partition and family arrangement, but they can mutually divide the property between themselves. That was what Kale held. That is the essence of Kale.
If that be so, my
But the
lord,
contrary was held in these two judgments.
and Damar Kali consider the section, that is why, my lord, Kali
So
goes
which
to
should
section
prevail, the
17.
subsequent judgments or Kale?
Well, that is why, my lord, section 17 to what extent it is there and how it has been considered in Kali.
But your judgments also consider 17 only.
Yes,
Both the judgments are on 17.
17. That is why Kale was considered and what was held. My lord, Kali turned to,
So these subsequent two judgments undo what Kale did to section 17.
if you logically consider page 757, my lord,
757?
775. You logically consider 775. After considering Kale,
Yes, what let us see that.
22-3. My lord, got it? The legal proposition on the basis of the aforesaid discussion be summarized as follows.
This is Kale being quoted?
Yes.
Yes.
Preceding paragraph, your lordship will find the Kale has been quoted. After
No,
that,
this is Bhup Singh.
No.
The Bhup Singh is-
ultimately 36, 37, Bhup Singh and Kale was quoted.
Yes.
Then, my lord, it is reduced what it was held. These are the points. If the compromise degree was to create for the first time rights and interest in property of the value of in favor of any party, the suit degree or would be required registration. 2. If you logically consider, now, therefore, my lord, it is not that it was considered Kale and also Bhup Singh and came to the finding, yes,
This was Bhup Singh which was being quoted in para page 775. This is Bhup Singh. Kale is only quoted by both the courts. But
And also
because the courts were of a different view, they just quoted Kale, left it there, and expressed a contrary view. Family arrangement, Kale was on family arrangement and estoppel. The estoppel arising out of family arrangement, which was distinguished from partition rather.
well, the family settlement, if the partition is also amongst the co-sharers of a plot of land, which have incident title. In the family settlement also the same thing. It is nothing new to the the partition and the family settlement
But if
discussion.
you say that, then Kale dealt with partition also. If family arrangement and
If then, my lord, that is why, my lord. If
Then
the partition, my lord, then your lordship can consider the state act.
what is the distinction between partition and family settlement?
Same.
If same, then Kale deals with partition also.
I'm assuming the partition, then the Kale has to be considered on the fact that the oral partition which was there, reduced in writing, you have acted upon that oral partition, you cannot take any contrary view.
And again, Kale
If that be so,
Kale was also prior to section 14.
now my lord my lord has to consider to what effect that the estoppel. Kale said estoppel cannot be operated because there is no provision. Will not operate so far if you did not act upon those settlement.
Just a contrary.
See.
Kale says entering into a family arrangement itself operates as estoppel.
Estoppel. Now I cannot challenge the same because there is no provision that
You
previous
cannot challenge the same.
I cannot challenge the same because they have already been acted upon and same was reduced in writing. That documents you cannot challenge. That was you cannot challenge the same. In other way. Now if you logically consider after the registration 17 came into force and 14, whether that document
no, the registration 17 was there at the time of Kale.
17 was there. But if the 17 was there, then also it says, my lord, that was ultimately the decision being subsequently it was held. That these are the necessary for the purpose of proper arrangement, family arrangement. It was held as family arrangement. If you logically consider.
Yes, exactly. So Kale was overruled without saying so.
By necessary implication, my lord, because your lordship will find.
No, but what was done was this Karkunnama.
What was done was the Khairun-nama created a right or not by that document itself. By the said document, if a right was created or not. That was not done. It was never.
No, but even a family arrangement creates a right.
Family arrangement.
As seen in Kale.
Family arrangement.
Because your 1996 document.
Created a right.
Yes.
There was a situation.
Your 1996 document created a right. Unless we take 1981.
With respect to arranging between the parties, what property will be used by what.
What is the difference between that and a partition?
There was no creation of a title. Partition can be, if there was no antecedent title.
If by family arrangement we say that I am entitled to this portion, you are entitled to that.
You take this, I take.
Why
this,
is it not partition?
Because if there is a distinction there with respect to antecedent title.
Partition also you have antecedent.
Doesn't always have an antecedent title.
It always has.
Can purchase.
No.
Somebody can
partition to have a partition, one has to be a joint owner.
Absolutely.
Having antecedent right.
Family partition can be between other co-sharers who are not a party to a family.
Family is a distinction.
Family is the only distinction.
The Karkunnama, was this between a family?
Khairun-nama, my lord, was something different. Khairun-nama.
Khairun-nama is not between a family.
No. 2022 তো
2215 was probably that Karkunnama or something.
Award or document of partition provided for effectuating a division of parties in future would require registration under 17(1). Whether an earlier wrong decision which has attained finality in regard to partition would operate as res judicata. This was the subject matter. Can we have a look at 759? What the Supreme Court was deciding, my lord, in that 22-3 judgment was this. Estoppel in a family arrangement was never the consideration.
What is a Khairun-nama? Let us see that.
Khairun-nama, my lord, your lordship will find that.
We hope that is not in the illegible page.
No, my lord, it's there. I have the book, so there is no problem.
Found that documents which are unregistered family settlement. Then
Yes, my lord,
the first paragraph.
did not say anything different.
So it's an unregistered family settlement.
My lord.
And ultimately it goes on to say that, and Kali was considered.
Kale was considered, and what did the Supreme Court say? Kindly see that. 36 first.
Yes.
That the family arrangement in the nature of a compromise, which was considered in that case, did not require registration. It was further held that since the existence of the family arrangement was admitted in that case, the same was binding on the principle of estoppel. Also, even if the family arrangement could not be registered, it could be used for collateral purpose, that is to show the nature and character of the possession of the parties in pursuance of the family settlement, and also for the purpose of applying the rule of estoppel, which flowed from the conduct of the parties who, having taken benefit under the settlement for 7 years, later tried to resile from the settlement. This was Kale, my lord, finding of Kale. Then Supreme Court, in this matter, my lord, sees 45. Doesn't say anything different.
No, what if you come to the 22-15.
22?
2022-15.
15 type yes.
15 is interesting. That
22-15, my lord.
yes. Para 36, 37.
Kindly have a look at 22-15, your lordship has seen.
Yes.
Can you see the
Para
first paragraph?
36. First paragraph says it's a family arrangement.
Have a look at it. Have a look at it. The High Court found that the documents which were the unregistered family settlement Kharundnama and receipt of such and such by the respondent were not admissible in evidence. Not admissible in evidence. And the Supreme Court is saying it is admissible in evidence at 39.
Last
And for 40, the appeal is allowed, impugned judgment is set aside. So Mr. Rai's submission on that is completely not correct.
Paragraph 27 to that.
27 to hold. That's an example given in another judgment.
Kale is being held as a court law.
Kale was not unsettled by this judgment.
It was not unsettled.
No.
Specifically. And para 36.
Yes, sir.
Para 36 says that if you apply the test as to whether Kharunnama in this case itself affects, it is stated otherwise that the document does not purport to by itself create, declare, assign or extinguish. But whether the Kharun
There, my lord, the Kharun
language, let us see the language of the Kharun.
that comes back to, my lord, the page 482.
Yes, read entirely. We are three brothers.
Now, 8.2, my lord, is it is further submitted that the respondent has admitted his signature. I'm sorry.
8.2. This is precisely what we are fearing.
Yes.
This is the illegible page. No, Kharunnama has been quoted.
Yes,
in para 10, next page. You can come to the next page.
8.2 ultimately cannot be evidence in নিল
আমার প্রথম থেকে মনে হচ্ছিল ওই পেজটা কিছু একটা থাকবে
Sees 8.2, my lord.
10 is Kharundnama entered. Kharundnama has been quoted.
Correct.
10 it has quoted. This Kharunnama was record of a past transaction.
Yes.
Your 1996 is not.
1996 is also 81.
No, it says it will.
Melody, that is, he reads one part and doesn't read the other part. The other part, because in page 13, your lordship will find it says that it's already been done in the 81 document.
Then why was it necessary?
It was necessary just to, for the sake of not getting into further litigation. And why it was more necessary, Milord, because Ognishikha, who got the property from the mother, had already built her property, Milord, of Mohan Manzi. And that
Yes, page 13 says so. Whereas by a family settlement,
my lord,
that is stood by.
Yes, that is stood by. That's only reduced into writing.
Marriage made some.
He said this is a family arrangement, but says not acted upon.
For avoiding further dispute litigation, that is probably what has been held in para 36 here.
Exactly.
But here the Kharunnama was It recorded past transactions.
Not even in.
Here you say 1981 transaction.
But the problem is, my lord, that the 96 document is not under challenge.
No.
Not under challenge. So he can't even make this submission here.
Yes.
And below 2022-3, 2022-15 go on to actually say that if a document of that sort is not required registration at all.
Very well. So you say in any event that 1996 states that there was a family arrangement, 1981, to avoid future dispute?
To dispute, this has been done. Because by that time, my lord, Ognishika had already made her, my lord, construction. He had done his whatever he had done with respect to, my lord, leasing out to IOCL, leasing out to, my lord, making a workshop. Everything he's done. He's enjoyed his property. He's built his own construction as well.
That is also there.
My lord. And he admits that. My lord, in none of these judgments, your lordship will find that the estoppel part was ever unsettled.
Was taken into consideration.
And Karunnama, my lord, which was rejected by the High Court, the Supreme Court says no, it has to be taken into evidence.
No, here the Karunama was different from your 1996.
No, I'm.
Yes, very well. Yes, Mr. Rai, you have to add anything else to add.
Only one thing, my lord, if your lordship can consider the documents which my learned friend wants to say.
1996 refers to 1981. There was
Yes,
already
what is 1981? That is what it is recorded. It is in the document itself.
What is 1981?
Page 12, last portion. Whereas after demise of Omiya Kumar Banerjee, my lord got it. The supplementary paper book. Page 12.
This is 96 itself.
Yes, there it was mentioned because by learned friend is saying this is nothing but which was there. It was mentioned in the.
Yes,
90.
yes.
Whereas after demise of Omiya Kumar Banerjee, Schedule 1 and Schedule 2 properties devolved upon his widow, 3 sons and 1 daughter having 1/5 share. Whereas by family settlement deed dated 22nd May 81, 3 sons of Omiya Kumar Banerjee and his widow allotted separate portion to Ognishika Banerjee for her 1/5 share in the Schedule 2 property. Ognishika Banerjee thereafter made some reconstruction. This is related only for the purpose to allow Ognishika Banerjee to take a portion of the property. It is there. It is not that what my learned friend is saying that these are also the part of 1980.
Cannot be allowed to say whatever he wants to. That's not.
No, it is on the document.
Mr. Rai is allowed. Say whatever you want. You want.
Sorry.
Yes, Mr. Say whatever you want.
So, what my learned friend wants to say today is interpreting a document. It is nothing but a.
What is the 1981 document?
Yes, that is not there.
That did not come on record.
And it is the signature of all the parties because they are also relying 96 document. Then my lord, kindly consider what is the documents and the things mentioned in the 96 document. Whereas by family settlement deed that such as 3 sons of Omiya Kumar Banerjee and his widow allotted separate portion to Ognishika Banerjee for her 1/5 share in Schedule 2 property. Ognishika Banerjee thereafter made some reconstruction because the mother wanted to gift her portion. The other brother also allowed. Yes, the specific portion be allotted to him. That is the 1981, and it has not been acted upon subsequently. It has some of the other portion is concerned. There is nothing to that. What my learned friend is saying, whether the 1981 documents, it is their documents they have relied upon. And it was, if you logically consider the last portion, whereas the exact settlement of Schedule 1 and Schedule 2 properties, page 13.
Yes.
By splitting up those proportionally is practically not possible, and such without hampering the interest of anybody. The properties in question have been divided amongst the parties, keeping in mind that the valuation of the share allotted to each party be equal. Whereas 2 sketch maps in one has been prepared such and such. Whereas for avoiding further dispute, litigation, and maintaining the peace of family, parties have agreed to make settlement. The first party eldest son of the late Omiya Kumar Banerjee will get DP and R3. And now, kindly consider আমি পুরোটাই পড়ছি।
6 নম্বরটা পড়।
হ্যাঁ, সব পড়ছি। Four, my lord, dear lordship, find Ognishika Banerjee will get BP1 and BP2 as per present settlement and the portion which she got previous settlement. So therefore, the previous settlement restricted to his, which his mother gifted to her in a particular portion. Subsequently, by this settlement, an additional portion is granted, that is BP1 and BP2. So therefore, my lord, even if whether the honorable apex court also came to the finding, if the document itself creates an interest over the property, after considering Kale, my lord, 22(3) and 22(15) also.
But then without overruling Kale,
My lord,
without overruling Kale specifically says if it's a family arrangement, then even if there's a legal bar, you are bound by estoppel. But then
Well,
that
estoppel
proposition
is
you are
even
saying
logically considered,
the
estoppel
Supreme Court
is
is deviating from that position, although it states about Kale, but is not following Kale. But where has Kale been overruled?
Now, my lord, both the three judges
Kale not a sentence in both of the judgments. We don't know whether the judges were the same. Probably not.
No.
Probably not. So two benches.
2022-15 is two judges make judgment.
Boy, yeah, right. Both
And
the
2003,
benches.
three make judgment.
So two judge bench probably Kale would override. If he find any contradiction between the two, Kale is three judge.
And 22-3 is three judges bench.
22, yes, 22-3 is three judge, right? So we have to content only on 2022-3. That is what I'm saying. So
Yes.
let us come back to 2022-3.
Once, if you
Kale was merely quoted.
after that, my lord, if you logically consider after Kale,
Kale features in paragraph 33.
Yes, my lord.
We shall now consider the citations, page 772, para 32.
After
We shall-
34, paragraph 34, if
No,
you lordship.
Para 32 says we shall now consider the
Kale.
citations relied upon, and Kale, para 33 features Kale.
Yes.
And then 34.
4.
Kale, what has been, the proposition has been called out.
Called
Para
out.
10 has been quoted.
4, my lord, Clerical
4, yes.
4.
Please come to 4.
It is well settled that registration would be necessary only if terms of the family settlement are reduced into writing. Here also a distinction should be made between a document containing the terms and recitals of a family arrangement made under the document and a mere memorandum prepared after the family arrangement has already been made, either for the purpose of the record for information of the court for making necessary mutation. Where the Kales?
Let us see Kale once. The original. Kale para 10. That has been quoted here. Para 10, if you come to para 10 of Kale, please come to 5.
Yes.
In fact, 5 has also been quoted here.
Yes.
Please look at 5. If you come to 5, Mr. Rai, you come to your 22-15. I mean, the one which you are. Here, para 34 and 4, you are relying on 4. 10-4 of Kale. Please
Yes.
come to 5. 10-5.
10-5. Yes.
That is also a part of Kale. Please read out 5 once.
That any rate the family arrangement was not proved by the appellants. My lord is
The members. Para 34 of
para
22.
Yeah, the members.
Volume 5.
The parties to the family arrangement must have some ancillary title claim or interest, even a possible claim in the property which is acknowledged by the parties to the settlement, even if one of the parties to the settlement has no title. But under the arrangement, the other party relinquishes all its claim or title in favor of
Under the arrangement, the other party relinquishes all its claims.
Yes. And acknowledge him to be the sole owner. Then the ancillary title must be assumed and the family arrangement will be upheld. And the court will find no difficulty in giving assent to the same, even in bona fide dispute. Now, my lord, these are the parameters which are held. After that, paragraph 35.
Yes, para 35. Come to para 35.
After reviewing the civil
This
judgment.
22 volume 3 actually.
Yes.
22 volume 3. Yes. Continue. Continue.
Largest senior counsel, my lord, he should.
Disturbing.
3 বলছিস না 15 বলছিস
35. This is frustration speaking because he understands that he is probably losing the. So ignore him. Para 35.
After reviewing the several judgments of the Privy Council and the other High Courts in paragraph 20 indicated the following proposition. Kale's case, my lord, 130, 20. So it was the Kale's case which has been quoted and considered. A family, following the general proposition, now it is called out. A family arrangement can be made orally. If made orally, there will be no documents on question of registration arises.
Let us
If-
come back to Kale 20, para 20.
Yes. Allahabad.
But it's a very, I mean, unenviable task for us. Because Mr. Rai, the Supreme Court committed a patent mistake in 2022-3. Can you say what is the mistake? In para 35 of 2022-3, Supreme Court says that after reviewing several judgments of this court, the Privy Council and the other High Courts, this court in para 20 indicated the following propositions. But it did not. It did not, because para 20 of Kale did not indicate those propositions. Para 20 of Kale was quoting Allahabad. Therefore, we shall hold that this is par inquirium. Supreme Court judgment is par inquirium. It wrongly takes into consideration a previous Supreme Court judgment. And we can do that. No difficulty. We have to choose between two judgments of three judge benches of Supreme Court.
Which is akin to law and what is...
Not only that, we have to ignore the subsequent judgment if it is par inquirium. And par inquirium can have various shades. It's very risky because Supreme Court very recently has said that this trend of high courts is very disturbing and we should not do it and whatever else. That we, but we cannot say that every judgment of Supreme Court is binding. But if there are two judgments, you are confronted with two judgments, right? Both are three judge benches. One takes into consideration the other. But there is a patent error, and we can say that in our judgment. We don't have any qualms. I mean, that 35 of 2022-3 proceeded on a patently erroneous premise by misquoting Kale. Therefore, why should we not hold that this is par inquirium?
Then if your lordship will kindly consider the earlier judgment which is considered, in the Kale, if your lordship kindly consider, why I am relying Kale, my lord, kindly consider paragraph
Yes. Kale para 10 is supreme.
10. That is the only thing, my lord. In other words, to put the binding effect and the essentials of family settlement in constitutional form, the matter be reduced into the form of the following proposition. The family settlement must be a bona fide one. The settlement must be voluntarily. The family arrangement must be oral, in which case of no registration. It is well said that the registration will be necessary only if the terms and family settlement are reduced into writing. Here also a distinction should be made between a document containing the terms decided as the family arrangement made under the document and a mere memorandum prepared after the family arrangement had already been made either for the purpose of the record.
You are reading which paragraph?
Kale from paragraph 10, 4.
Yes. Yes.
Itself does not create, extinguish any right of immovable properties and therefore does not fall within the mischief of section 17(2) Registration Act and is therefore not compulsory registrable. So Kale also considered in this, and it was ultimately, yes, 4 is there. Now, my lord, Kale consider where the legal bar is there, whether can be estoppel there is cannot be any estoppel against the statute.
That argument made in Kale.
Here, my lord, if your lordship kindly here, my lord, if your lordship kindly consider what is the facts.
But para 4, sub-para 4 and 5 of Kale are apparently contradictory.
That any right of family arrangement is not proved by appellants as a fact. After that, the doctrine of estoppel. Whether there can be any estoppel against the statute. I put this question to myself.
Says there is estoppel on you.
And a document which itself does not create any title over the property, whether I need to challenge the same for the purpose of section 34 of the statute.
There's a contradiction between para 4 and 5, subpara 4 and 5 of para 10 of Kala itself also.
And it was admissible that the petition filed before the ninth Tahsildar embodied the terms and conditions of the compromise, and as such was compulsory registrable under the Registration Act, and being unregistered, it was inadmissible in evidence. Before the Tahsildar, my lord, this is a family arrangement was made prior to that. After that, for the purpose of mutation, they have recorded the sales, but the properties are going to be partitioned. That was placed before the Tahsildar. If you logically consider Kale, what is the facts there? Initially, there is oral partition admitted by the parties. It is not just challenging the oral partition because that is available, that is permissible
In your case, all this will always be necessary because you did not challenge 1996 and 1996.
49 considered.
We can bypass this issue also altogether.
49, can you consider 49 of the Registration Act? In the state itself, it requires, if I want to make any settlement or to give any property, my share is there. It is not that my share was not there. My share was that I want to relinquish my share from that property. Whether that
2015 document is a registered document.
Yes.
1996 was the prior exposition of the arrangement.
Only that portion. Why not? You'll find
15. You are challenging 2015, right? 2015 relies on the arrangement made in 1996.
If
That's
that
all.
have no legal effect, whether I require to be challenged or not. Because it is not reduced in writing of 1981. That's why I draw your attention to the portion.
It may not have legal effect in the sense that it itself may not transfer rights, even if we proceed by that. But that becomes a prior exposition of arrangement between the parties for the purpose of 2015.
Then I am not a signatory to this 2015.
All right.
I am not the signatories of 2015.
All right.
Because what is followed by lordship, it is that the arrangement was made, that subsequently it is not that. They are claiming that 96. My case is
If that was treated to be the previous arrangement,
yes,
then all the parties there had to be parties in the subsequent also. Very well. We'll have to look into Kale. Because Kale itself is contradictory. 4 and 5 are really contradictory.
And if you're lordship, can you consider whether this section 14 was that the state act, it is a special act, whether there is overriding effects over the other.
Section 14 is very serious in spite of any judge, notwithstanding any judgment, that is also there.
And section 14 is, if the state act, well, notwithstanding anything contained in any other
law or judgment.
law or judgment, what?
No, if because state it is it concurrent or state? Which
Concurrent.
list? Concurrent list.
Land reforms comes within the concurrent list.
If it's concurrent list, then I mean that's another dicey situation. Because any law, can you say in a state law any law? Because if there's a central legislation and a state
It's
legislation
a settlement of land.
on the same, we'll have to see the 7th schedule once. If it's concurrent, then it's very difficult for a state legislation to say that this will also prevail over central legislation.
Your lordship was talking about 10.4 and 10.5
Of Kale.
of Kale. That is one aspect. Well, Kale is not reduced to that. Well, the estoppel part, which comes in completely differently from 10.4 and 5. Well, the 10.4 and 5 is a situation which has been said. It's not contradict. It will be contradictory.
But para 10 says, in other words, to put the binding effect and the essentials of a family settlement in a concretized form, matter may be reduced in the form of the following propositions.
Absolutely.
So 10 lays down the propositions. That is the final
situation.
Yes.
Those were the situations. 38 is the paragraph which comes into effect with respect to law. 38.
Yes.
Yes. Assuming, however, that the said document was compulsorily registrable, for section 14, the courts have generally held that a family arrangement being binding on the parties to it would operate as an estoppel by preventing the parties after having taken advantage under the arrangement to resile from the same or try to revoke it. And he hasn't even tried to revoke it. So 38 is the paragraph. 10.4 and 10.5 are situations.
This is under Article 39. It is have a
And he cannot. And Mr. Mukherjee is absolutely right when he says that this is an estoppel which is of equity, which is operating against him. 14 minute is not higher than 17.
Cannot be established against statute. That is a higher principle.
Argument made, Milord, in Calais, that
Yes.
there cannot be an estoppel against statute. Kindly have a look at that.
And my lord is asking what is the
Argument made, which was, Milord, shut out. Kindly have a look at paragraph 7 ki 8 tak. Yes, paragraph 8, number 6. Specific argument made. Mr. Sharma, Learned Counsel. Sees, Milord, 8.6.
Yes. Replace that also.
This, that the doctrine, Milord, this is the argument of Mr. Sharma. The doctrine of estoppel would not apply because the family arrangement being compulsorily registrable, there can be no estoppel against statute. That is being, Milord, refuted in 38. Specific submission made which is refuted. Mr. Rai, in his usual fairness, Milord, is trying to, Milord, dilute it. But this was the submission made before the Supreme Court, that there cannot be estoppel against statute. Milord, in a peculiar situation, in a family arrangement, there he will run an estoppel against equity, or rather on equity. Sees 24 and then, Milord, goes on to 38. Because the Supreme Court reserved its right, Milord, or rather reserved its verdict on estoppel there in 24.
But in Calais, probably the family settlement recorded a previous.
Yes, my lord.
This also.
No, here Mr. Rai has a point, Mr. Chatterjee. The difficulty is if the 2015 document gives effect to that the prior arrangement, it just records that arrangement, then he also had to be a party.
Milord, if
Some of you cannot say
in
that.
the 96 he did not, he was divested of his right with respect to the 2015 property.
That is precisely what he says.
Yes.
In Calais also, that the family arrangement itself did not create the right. It recorded a previous
Milord, even the 96,
arrangement.
my lord.
96 did not record a previous arrangement as such. It referred to 1981, Mr. Chatterjee. But it went on to say something else happened after that.
Yes, and then that was
for that reason it was necessitated that 1996.
Absolutely.
So then 1996, if 1996 itself created the right,
did not cater. That's exactly what my point
it
is.
continues to be will. It will.
A second. Beloved, if this was an argument where in a suit made where 96 was under challenge, I would have understood.
No, 96 is not under challenge. Let us suppose for the time being that 96 was the mutual
Then,
arrangement.
Milord, if 2015 goes, then your lordship has to say, Milord, 96 was invalid.
No, not necessarily. Because suppose 1996 itself by its own strength is invalid. That may be a valid argument because it was required to be registered.
Challenge.
No, not challenged.
Binding inter se parties, Milord, Abhara Nishan Gupta.
But 1996, if 1996 was the prior premise of this 2015, if you say that 2015 recorded what was already done in 1996.
I have not said, he has said in the plaint. I have not said.
Yes, if that be so, that 2015 had to implicate all the parties.
2015
to 1996.
A part of the party of the properties which was a subject matter in 96 and 81. Milord, there were 3 or 4 properties in 96. Milord, some
Very well, you say yes, right. 1996, they are bound by estoppel. That we should cull out from Calais.
Started from 81.
Yes.
Was in the middle part in 96 and culminates, Milord, in 2015. 2015, Milord, is with respect to not with the entire property. What he gets, he is already got. He's already got and he's enjoying his property.
That aspect is there also. He has been blowing hot and cold.
He's enjoying his property and he's admitted that. So he can't have it both ways. Milord, today what your lordship is really deciding is whether this 2015 document is invalid or not.
Yes.
Lord, may I ask this question to myself? How is it invalid? No arguments made on that. He is on, my lord, going on 96 document. Why is the 2015 document invalid? May I ask?
But 2015 is invalid. He's saying because it's bad for non-joiner of all the co-owners. He was one of the.
He is not. He is saying
1990. His case is very clear. 1996 did not create any right in favor of
was
anybody.
not acted upon.
Even if it was acted upon in law under it is in contravention of section 14. There cannot be any estoppel against the law. Therefore, it did not create any right in anybody's.
That part of the Lord, if it that needed to.
And
be
if that be so, then it remains joint, and he had to be implemented in 2015. That is his argument.
If it remains joint, then even my lord, all properties had to be below partition.
Right.
That also he has not prayed for.
He need not. He wants to remain joint because he's enjoying the fruits of that.
File a dispute, but he will want to remain joint. Can't happen.
He's taking benefit of that. That's why he's not.
He'll be a dispute. There will be a dispute, but it will remain joint. My lord, both can't go together. Plaintiff can't have my lord, a mutually destructive claim.
He'll have the cake and eat it too.
Eat it.
Proverbially.
That's exactly what he wants. But he cannot.
And so far, my lord, this
Land
Land Reforms Act, my lord, in view of Article 39. Land Reforms Act,
Article
enactment of Land Reforms Act, it is declared that this act is for giving effect
Your
to
lordship will decide in that preemption.
to the policy of the state towards securing the principles specified in clause B and C of Article
So
39.
seventh schedule. What is the seventh schedule position?
And thus, yeah, seventh
Is or concurrent?
Seventh schedule is concurrent.
Concurrent is okay. Now we'll have to check up.
The preemption part was
So land reforms.
made by the was protected by the seventh schedule. Seventh schedule is land is concurrent.
We'll check up seventh schedule. Definitely.
acquisition of land, settlement, and other
No,
things.
no, acquisition is
Seventh schedule.
union.
No, seventh schedule. That is the 48 Act alone.
Land reforms is not exactly acquisition of land.
Land
that
reforms
is
is
the-
not acquisition. At
Acqui-
times it is. Basically, my lord, at
Maybe,
times
maybe,
it
but.
is.
So we will close arguments on this. Heard learned counsel for the parties. The matter is reserved for judgment.
Written notes, my lord, that space that required.
Very short written notes. File tomorrow, whatever. Just the not still. Just the you can give the page numbers. We have taken notes on the page numbers. Facts need not be not a detailed written notes. Only the bullet points. 2 or 3 bullet points. I mean his whatever you are. আচ্ছা না judgment is reserved করলাম তো judgment reserved না করে the matter be listed tomorrow under the heading to be mentioned for the purpose of enabling learned counsel for the parties to file the respective written notes of arguments, brief written notes of arguments. Do it tonight. Yes. Thank you very much. Yes.
Item number 45.
We are not starting any new hearing. 20 minutes we can't finish with this composition. What is the challenge against? Substantive challenge or rejection of plaint or something like that? Small.
No. The challenge is the judgment. Judgment and or decree.
Oh, full
Judgment and decree of a suit.
And suit decreed on my counterclaim, declaring my 1/3 share.
I am for the appellant.
Right. We'll keep it on next Monday when Justice Kumar returns with the regular benches.
Next Monday.
Yes, before that we don't have the
yes,
regular composition. That's why. Since the regular bench is not sitting,
On Monday, the regular bench
will be sitting.
And in
Let the matter stand adjourned
by
till
this time it cannot be concluded.
let the matter stand adjourned till January 13, 2025, when the said bench is scheduled to be resumed. Finish করতে পারবো।
Item number 46.
Probably same applies, Mr. Laidi. Did they appear on the last occasion?
Yes.
Then
wish to make some orders, my lord. We wanted time to file supplementary papers. Because
yes.
because all the
Paperbook
documents
দিতে
were
হবে না।
not contained.
Paperbook দিতে হবে না, এটা দিন।
Last order, lordship sees the lordship's last order.
Yes. আচ্ছা শুনুন না, এই অর্ডার গুলো যখন সাজাবেন না, লাস্ট অর্ডারটা উপরে থাকবে।
ডিপার্টমেন্ট যখন করে দেয় সেটা
ডিপার্টমেন্ট হাত দেয় ফাইলে?
কোন ডিপার্টমেন্ট থেকে এসেছিল মতো
না না,
ও আজকে
আমাদের লাস্ট অর্ডার যেটা হচ্ছে জাস্টিস কুমার আর আমার, সেটা তো আপনাদের এখানে হয়েছে। এটা তো তলায় বাঁধা রয়েছে, সেটা তো একদম উপরে থাকবে, তলা থেকে উপর দিকে আসবে। হ্যাঁ, yes, those were returned also. The paperwork were to be returned to them, and
Yes.
they are not appearing today. Ms. Mukhopadhyay was there in the morning.
In the morning, I had to talk with her.
Yes, we saw you have a talk with her.
She said that she will be requiring at least a fortnight's time to obtain return of the papers and then to prepare.
Mr. Lahiri will record that and keep it after a fortnight.
As well.
Will not record that talk about the talk.
Yes, that's right.
None appears for the appellant at the time of call. Full stop. By a previous order dated December 18, 2024, comma, the paper books already filed in the department were directed to be returned to the learned advocate on record for the appellant and to be refiled on the returnable date. Full stop. Next para. A further direction was given to the appellant to file requisite number of supplementary paper books incorporating all omitted relevant documents pertaining to the list on the returnable date. Since no such supplementary affidavit has been filed and the appellant is not represented today, comma, we extend the time for filing such supplementary paper book and filing and refiling the original paper books for a fortnight from date. Full stop. The matter shall next be listed under the same heading on January 21, 2025. Immediately after that fortnight, Tuesday week.
Monday.
Not Tuesday week, Tuesday after that.
Tuesday. January 21st.
21st, right.
Will be given some precedence, my lord, in the list.
Mr. Lahiri, these matters automatically, I mean, the next other matters will come below this because these are already up
Here.
in the list.
As you.
item number 47.
Please, this is my appeal.
Yes, Mr.
Uh,
What happened to you?
uh,
Some, we hope not some clients.
No, nothing serious. It's an ex parte appeal. Respondent is not appearing in spite of notice. In the trial court also, they did not contest the matter.
Yes.
They got to the probate.
What is the ex parte appeal? But your probate application was dismissed.
My probate.
Why dismissed?
The learned judge was of the view that everywhere in the will, it was mentioned, the date was mentioned 16 January 2003, the date of execution of the will.
All right.
Only where the testatrix signed the will, there the instead of 16 January 2003, it was mentioned 16 January 2005. Although the Bengali date relates to that, falls to 16 January 2003.
When did she die? The testatrix or testator?
Died on 1st February 2007 and the deed was executed on 16 January 2003.
So what would be your argument on that?
So far as the will is concerned, if your lordship kindly see the will itself, that is in the part 2.
Part 2?
First page.
First page, yes.
First page. Your lordship will find this is a will.
This is not a holograph will. Not her own handwriting.
Type.
No, this is handwritten.
It is handwritten here.
But scribe.
First type. In the will, the date was mentioned 16 January 2003. It was notarized also. The notary also, it was notarized on 16 January 2003 itself. That is at page 7, part 2, page 7. You will find is notarial right hand side, notarial certificate number
Yes.
such and such, dated 16 January 2003. Everywhere, it
Everywhere
is
else.
16 January 2000. But if you lordship kindly come to the page 5. Page 5.
below, at the bottom.
Yes.
No, like,
Yes, yes.
in the left hand side, it is meant Sean Doshara mark. It should be like 1400 নয়, মানে it is not 2400 নয়, 2400 নয় has not yet come. মানে the ইংরেজি তারিখ 15ই জানুয়ারি 16ই জানুয়ারি 2005. মানে the learned judge say this is suspicious because the everywhere although it is mentioned 2003, but only in page 5 it is mentioned 2005. And my lord, one more suspicion about in page 6, if your lordship kindly come to my lord, page 6, মানে প্রস্তুতকারক উইল কর্তৃক কথা মতন এই উইল প্রস্তুত করিলাম এবং মর্ম অবগত করাইলাম সহি জগদীন্দ্রনাথ গাঙ্গুলি অ্যাডভোকেট 16 January 2003 Asansol Court. The learned judge says this 16 January 2003 has been overwritten. Without going through the original will, it can't be said whether this is overwritten or not. I have not gone through the original will. That is before the honorable court. With the
will test original register থেকে আপনি এটা আচ্ছা দেখ আমরা এটা একটুখানি না like what is done when
yes
the copy is served and the litigant does not want to show that he has seen the document.
Yes.
It has to be that meticulous. Does not appear to be overwritten from the photocopy.
I also find
Yes.
but
Ink, let us see the ink.
recording is there of the learned judge.
Yes, the judge was in a better position.
Yes.
Yes, there is override. 2003, there is override. Clear override. Overwriting policy. Let's put it.
Fourteen 1409 relates to 2002 of the year English calendar month 2002. That is wrong, but because I have find it out by searching that it is
2003.
2003 and 16 January 2003.
So that third point is not. I mean, কিন্তু কিভাবে এটা কি লাভ হবে না ধর এটা যদি অ্যাকচুয়ালি করে থাকে এটা নোটারাইজড হয়ে গেল নোটারাইজড করলে তাহলে কি কি ওর কি কারণে করতে পারে কি বেনিফিট হবে না যাতে জালি করতে চায় 2003 তে নোটারাইজ হয়ে গেল নোটারাইজটা তো হয়েছে ওই দিনই বাকি সব হয়েছে
The son of the testatrix is the witness in this will.
You are the
you
are the executor and the beneficiary.
No, I am the executor.
And who is the beneficiary?
Beneficiary is Rupendranath Pandey, who was looking after the lady since her son was staying abroad.
And what is your relation with the lady?
I was an advocate of the testatrix.
You are Jagadindra, Mr.
Yes, yes, I was Jagadindra.
We are trying to understand what benefit could be derived by this manipulation. I mean, she signed later, 2005.
The executor is concerned he's no more way benefited.
No, he may have a collusion with Rupin, the beneficiary.
Yes.
But that is beyond the.
Yes,
I mean,
because everywhere,
Yes.
everywhere in the will, it is mentioned 16 January 2000.
You were
Even
try-
if the before the notary, it was notarized in 2003. Notary signed is that in 2016.
is the
January
only thing
2000.
which could be that she signed afterwards. But mention of a date, I mean, if a signature is not disputed,
Signature is not disputed.
citation was made.
Citation was made.
Who are the heirs?
The son was the heir.
He
After
was
the
in
death of the son,
his heirs.
his heir.
So they did not
his
object.
heirs, by writing a letter to the
No
court
objection.
says we do not have any interest over the property. We do not want to contest.
We are trying to understand what could be achieved by her by, I mean, putting the date wrong. I mean, let us suppose the other way around. I mean, 2005 was the actual date when she signed. How could it be notarized before that?
Yes.
What is the imprint letter we can dispose of?
That is at page 54 of the part 1.
Yes.
May I proceed, Madam?
Yes, sir.
The fact of the case is that the deceased Renuka Datta was a permanent resident of 67 Buddha Mission Compound, Post Office, Asansol District, Bardwan, and during her lifetime, she prepared a will on 16 January 2003 in respect of her property as above, whereby bequeathing in favor of one Rupendra Kumar De. In the said will, she also appointed the present petitioner as the sole executor. It is also the case of the petitioner that at the time of execution of the will, said Renuka Datta was physically fit and mentally sound, and the will was prepared as per her instruction by this executor. It is further case of the petitioner that the said Renuka Datta is the wife of late Kalika Kumar Datta, who predeceased her, and she died living and surviving her only son as her legal heir, being Anupam Datta. The present petitioner filed a will for obtaining probate before the district delegate Asansol, but as the objection was raised, the case became contentious and the application was filed afresh before the learned court of District Judge Bardwan. Subsequently, the said proceeding was dismissed for default because of a mistake on the part of the advocate's clerk, and accordingly a miscase was filed, being miscase number such and such, and the same was allowed. The present proceeding started and the matter was thereafter transferred before this court for disposal. In course of the proceedings, the only legal heir, that is Anupam Datta, expired on 4th July 2009, living and surviving his wife Irena Datta and son Rafi Datta, who are the residents of Germany. After said legal heirs were being substituted, notices were sent and they informed by the letter that they are not interested in these proceedings and renounced the law of inheritance, and subsequently the matter has been fixed for ex parte before this court. Learned advocate for the petitioner submits that the executor has proved the will by giving evidence of one attesting witness, and there is no other contrary evidence to show that the will is manufactured or the deceased had no mental capacity at the time of execution of will, and accordingly probate should be granted in favor of the executor. Heard the submissions of the learned advocate, on careful perusal of the record, it appears that there is no other contesting party in this case, and from the record it is also seen that the notices were sent to Germany and the same were duly served, and it also appears from the letter that the said legal heirs of the deceased Anupam Datta renounced the law of inheritance. However, from the above it can be said that they did not come forward to contest the proceeding in spite of due service. Now it has to be seen how far the petitioner executor has been able to prove that the said will dated 16 January 2003 was executed by Renuka Datta, or whether she had mental capacity to execute the will at the time. Now it is seen in order to prove the case, the petitioner has cited himself as PW1 and he identified the will and said that he prepared the will as per instruction of Renuka Datta, and after the said drafted was made by him and the same was approved by the deceased, the same was typed as Asansol Court by one Prashanta Rao, and thereafter he put his signature there as advocate. He also said that he had read over the contents of the said will to the testatrix, who also put a signature in their presence in all pages. The witness also proved his signature marked as exhibit 1 by 1. He also filed the death certificate marked with Exhibit 2. One Krishnendu Kumar Kaur deposed as PW2, and in his evidence he said that the deceased was the owner of the property as described in the will, and during her lifetime she made the will on 16 January 2003. In support of her property and the said will, he has the attesting witness and he visited with Renuka Datta, and on her request he witnessed the execution of the will. He also said that Renuka Datta was in a sound state of mind at the time of execution of will, and she put her signature on the will. After understanding the contents and thereafter in presence of himself and two other persons, namely Kaji Iftikhar Alam and Anupam Datta San. He also said that he and the said two witnesses saw the statistics to execute the will, and the will contains the signature of Renuka Datta himself and other witnesses. He also said that he filed his affidavit in chief, which was written as per his instruction by his advocate, and after going through the same, he put his signature in each page of this affidavit. He proved the said will, which was executed by Renuka Datta, marked Exhibit 1, and also identified the signature of statistics, which are marked with Exhibit 1/2 to 1/9 series. And in the last page of the said will, his signature is appearing as marked as Exhibit 1/10. Now, on careful perusal of the said will, which has been marked Exhibit 1, it is seen that it is a notarized will, and the notarial stamp has been given dated 16 January 2003. It is also seen that at page 3 of the will, at the bottom of the bottom portion, the date has been given as per English date 16 January 2005 and Bengali second mark 1409. It is also seen that the present executor, being the advocate, put his signature, and the date has been mentioned as 16 January 2003. There it is also seen that 03 has been overwritten. Now, from the evidence as adduced by the executor as well as attesting witness, and also from petition for grant of probate itself, it is seen that everywhere it is mentioned that the will was dated 16 January 2003. Now, this court fails to understand then why the date has been mentioned as 16 January 2005 at the last portion of the said will, as it appears that the notarial stamp has been of the year 2003. It can certainly be the said the will must have been executed either on that date or any prior date thereto, but certainly that will never imply that the will was executed after the document was notarized. Now, if we even calculate Bengali year, then also it will appear that it is of 1409, which corresponds to English year 2002. If that's so, then certainly it can be said that the will was not executed by the testatrix herself on that date, or she did not sign on the date mentioned in the will. It is the mandate of the law that while granting an order of probate, the court must put himself in the armchair of the testator, and it is to consider the entire facts and circumstances. Since this will is taken up for hearing for expertise, it cannot be said that the executor is not to remove any suspicious circumstances which arise, if any, in proving the said will. In this case, nowhere from the four corners of the case it appears that any explanation has come before the court, that why the date of the will is not tallying with the date when the will was notarized, or as stated by the executor attesting witness himself. It is the primary duty of the propounder to prove the will, and the court must be satisfied that the will which was duly executed and attested. The expression due execution does not merely imply the fact of execution, but also something more. It means the execution effected by the executor with knowledge and approval of the contents of the will. When, however, there are suspicious circumstances which may suggest that the alleged will is unnatural, improbable, or unfair, the onus of the propounder is to explain them up to the satisfaction of the court. Normally, in a regular form of the will, the executor used to append a clause in his own handwriting that he signed the will in presence of the witness who had seen him to put his signature, and the witness signed in presence of each other, and then a presumption would have arisen that the will was duly executed and attested. In this case, the testatrix signed both the bottom of the page as well as the right hand corner of the page up to page 4. On careful perusal of page 4, it is seen that practically there was no reason on the part of the testatrix to sign at the bottom of the page after typist signed specifically when this will have been prepared by an advocate. Now, if we go through the evidence of PW2, also it would appear that he said that testatrix put her signature in the will in presence of himself and two other persons, namely Kaji Iftikhar Alam and Anupam Datto, and PW1, while tendering his affidavit, said that he read over the contents of the will to the testatrix and thereafter she put her signature in pages. In his affidavit in evidence, he himself said that the testatrix put her signature in presence of the attesting witness, and there were 3 attesting witnesses. Therefore, the executor failed to prove whether the testatrix signed in presence of the attesting witness or in presence of him. This PW2 also did not state at the time of execution this PW1 was present within the room. Therefore, the evidence as adduced by the petitioner and the attesting witness does not appear to be trustworthy enough to consider. The age of the testatrix also cannot be ignored, as she died at the age of 91, and certainly on the date of alleged will she was about 87 years. So certainly the petitioner is to prove that at the age also the testatrix has sound mental capacity to execute any document. So after careful consideration of the above facts and circumstances, it does not appear that the petitioner being executed has been able to prove the said will being marked with Exhibit 1 was executed by Renuka Dutt on 16 January 2003.
You want to cite any judgment, Mr. Ray?
Well,
This is not a judgment-oriented case. So this is. So your argument is that these are irrelevant. I mean, these mistakes.
Yes.
We'll conclude arguments. We'll go through.
Right.
What we are concluding right now. We'll pass judgment.
Yes.
It apparently seems, subject to what my learned brother says, that the date was also put in by the scribe, by the advocate. দেখ এই পর্যন্ত advocate করেছে signature was put by the testatrix. What happened? The same advocate signed and committed a mistake. He wrote 2005, and consistently with that, in the previous page also he wrote 2005. Yes, but in the second page where he signs, the advocate, there is a short signature of the advocate, which is the court overlooked. There is a short signature, JG, which is Jagadindra Gangu. So where he gives the wrong date and corrects his overrides, there is a signature beside the overwriting. But he forgets to correct the date. The same mistake was committed by the same man. But the signature is not denied. That is the difficulty. And one other thing, contradiction between whether he said that the attested witness said that he saw 2 attested witnesses, but in other place, and we find the signature of 3. Even if the third signature is superfluous, probably, I mean, 2 with attested witnesses, section 63 and those provisions are satisfied. Act order record the original will, which is a part of the records, is contained in an envelope, pushed up on the direction of the court, the said envelope is opened and the original will is perused. Pushed up, next para. Heard learned counsel for the appellant, pushed up, since this is an uncontested matter, hearing is concluded and the matter is reserved for judgment. এটা আবার খামে ঢুকিয়ে খুব সাবধানে এর সঙ্গে পাঠিয়ে দেবে। ওই খামে ঢুকিয়ে ওই ফাইল, হ্যাঁ, যেরকম খামে ছিল খামে ঢুকিয়ে আবার ওই ফাইল কভারের মধ্যে করে পার্ট অফ রেকর্ড করে পাঠিয়ে দিন। থ্যাংকস। দিয়েছি দেখেছি জানি। Yes.